let's come back from the lunch break, please. Mr. Rankin, are we turning to Ms. Montgomery? Mr. Tucker.
Hi, good afternoon,
All right.
Madam Hearing Officer. Aaron Tucker for the record, and I'll be examining Ms. Montgomery.
And she's on the platform, as I understand it.
Yes, she's on the platform.
Sheila, will you give her the permissions, all the permissions?
And if I could please get permission to share my screen.
Ms. Montgomery, would you spell your first and last name for the record, please?
Yes, it's Kelly Montgomery, Kelley, last name Montgomery.
Thank you. And do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead, Mr. Tucker.
Thank you very much. Ms. Montgomery, could you please state your name and your role at OCC?
Sure. It's Kelly Montgomery. I'm employed in Houston, Texas. My current responsibilities are I'm the vice president of our air programs, but I spent the last 10 years as our regulatory director in the Permian.
Thank you. Could you please describe your educational background and professional qualifications?
Sure. I have a BS in mechanical engineering and am a registered professional engineer in Texas. I have been with OCC for 34 years, and in that time I've been a production engineer, an environmental engineer, and then the latest is the regulatory director.
Is OCC Exhibit C a copy of your testimony?
Yes, it is.
Do you have any changes or clarifications to your testimony?
No, I do not.
Let's go to slide 2.
Okay.
Could you please give us an overview of the current framework for temporary abandoned status?
Sure. The existing rules for temporary abandoned status are really in 3 bullets, as you can see here. We have 1915, 25, 12, and that's where the rules give the OCD authority to place wells in temporary abandonment status, and I may say TA status as we go on so I don't get tongue-tied, for up to 5 years. And they also provide discretion to the division to extend the status for good cause shown. Also in that portion of the regulation, they limit the number of TA'd wells an operator can have depending on the size of the operator, number of wells they have. Second bullet or second portion of the regulation is 1915, 25, 13. And this talks about the evidence that an operator needs to submit on the casing and cementing, etc., when seeking approval for TA'd status. And finally, we get to 19, 15, 25, 14, and this identifies the mechanical integrity that we must perform in order to seek approval for temporary abandonment status.
Thank you. And are you aware of any deficiencies with the existing process for temporary abandoned status?
No, I'm not.
Let's go on to slide 3. What concerns does OCC have about WELC's proposed limitations on extensions for temporary abandonment?
Sure. So first, I'll just orient you a little bit. These slides are very similar to Ms. Wallace's. You have the WELC proposal on the left in red. You have OCC's modification that's shown in kind of the green highlights, and then kind of the rationale for the reason. So I'll pretty much focus on the rationale. What we're proposing is to eliminate portions of the WELC proposal, of the additions here in subsection B, that limit the authority of the division to extend the temporary abandonment status to longer than 2 years. So we believe the division should retain full discretion on the length of time a well may be eligible for TA, and there's a couple reasons for that. We are very heavily involved in enhanced oil recovery projects. We've been very successful with these projects, and these projects definitely benefit from an inventory of TA'd wells, which we'll go into a little bit later. Well, actually, I'll talk about it now, and I'll show a graph of it later. We have some examples in our Hobbs unit where 49 wells that were TA'd were converted to either production or injection, and they have had amazing results. When you convert these wells, they can take a long time. And there's a variety of factors for that. We have, you have the economics, you've got the regulatory hurdles to get you all your approvals for your injection, you've got infrastructure concerns and timelines, and then just the general technology.
I'd like to stay on this slide for just a little bit longer. Welk proposes to require that extensions be subject to the adjudicatory proceedings in 19.15.4. Oxy is opposed to that change, correct?
Correct.
And can you explain, provide an explanation for why Oxy has concerns with requiring a hearing for extension requests?
Yes, I think it's logistically impractical. When you are looking at an extension request, you have a very, the timing that it takes to get on the docket, to put it together, and to get an actual order. I worry about our compliance from a division standpoint and from an operator standpoint, that time frame it takes to get to that point.
Thank you. Let's go to slide 4. What concerns does Oxy have about Welk's proposed eligibility restrictions for temporary abandoned status?
Yes, so Oxy, we propose to eliminate a portion of the proposed additions in subsection C. And this section right here that they've added limits the eligibility of wells to be in TA status to only those that have been inactive for less than 3 years. We believe the division should retain full discretion, as I said earlier, over the wells which are eligible for TA status. EOR projects, enhanced oil recovery projects, they frequently benefit from an inventory of TA'd wells, and many of these wells will have been inactive for 3 years or more. And if we allow wells that can pass and do pass mechanical integrity testing to be granted TA'd status, it won't only assist in continued help with our enhanced recovery, but also it prevents operators from having to prematurely plug wells, or in Oxy's case, having to drill new wells for our EOR projects.
Let's talk a little bit more about enhanced oil recovery. I'm going to move to slide 5. How are wells in temporary abandoned status utilized in enhanced recovery projects?
So I can give you some examples of how I've seen it used. And when I take like the South Hobbs unit in particular, when it was on primary and water flood, we were on 40-acre spacing. Then we went to, 40-acre spacing. Then we went to 80-acre spacing at the initial. And then over time, we have come back and reworked these wells to target different zones, to manipulate the flood, to work with to understand how the flood's going. So we've used these to turn on and off different portions of the field. I've even seen projects that I've worked on in my past that go down to 10-acre spacing. It varies as you're working the flood to try to make the best of your enhanced oil recovery project.
And what are the timelines for developing enhanced oil recovery projects?
Oh gosh. So they can take many years. I can say just in particular the South Hobbs that I was involved in, we went to hearing in 2012 and 2013 and didn't end up actually putting starting the flood until maybe around 2014, 2015. And the logistics of that are your regulatory approvals, and then of course your infrastructure changes. There's a lot of infrastructure changes that are associated with these type of projects.
Thank you. Moving on to slide 6, what safeguards exist for wells in temporary abandonment status?
Well, we're not proposing to change any of the existing rules that provide the safeguards. You have your mechanical integrity tests that these wells have to demonstrate to show that they do no harm, and they have in casing integrity. All we are asking really here is for the division to have discretion to tailor the time frame for a temporarily abandoned well to the conditions of a particular circumstance, particular operator, particular well.
Thank you. I'd now like to move to Ms. Montgomery's rebuttal testimony. Ms. Montgomery, what is Oxy's response to Wilk's proposed time limits for temporary abandonment?
Well, the proposed timeline would give operators a maximum of 7 years to either return the wells to beneficial use or to permanently plug the well and restore and remediate the location. This whole time frame is just premised on the idea that wells in TA status for longer than 7 years don't have a beneficial use, but we can demonstrate that hasn't been the case for Oxy.
And can you provide us some specific examples showing the value of wells in temporary abandonment for more than 8 years?
Yes. Do we want to? Yeah, there we go. I look like I froze up for a second. Can you still hear me?
Yes, we can hear you. Thank you.
Okay, I apologize. I'm on Wi-Fi today. So let me orient you to this graph here. On the bottom is time, and time goes from the 2000s all the way to present day in 2025. What you see on the left is your oil production in barrels per day, and that's represented by the green line. And then on your right, you're going to have gas production in MCF per day, and that's represented by the red line. So what we did here is we looked in our Hobbs unit that is in New Mexico and I'm most familiar with, and we took 49 wells, and these are wells that have been in temporarily abandoned status for varying lengths of time. And in the last 10 years, you can see very clearly when we started bringing wells back on either to production or injection during that time. And so you see you go from a very flat or declining oil to, I don't know, double, triple, quadruple, and more the oil production by bringing those wells back online.
In this graph, do you know how many of the wells were in temporary abandoned status for more than 8 years?
Yes, so we have 45% of those wells, almost half, had been in TA status for more than 8 years, and 21 have been in TA status for more than 10 years.
What would have been the consequences if Welk's proposed rule had been in place for these wells?
Yeah, these wells would have been plugged and abandoned. We would have lost the assets, and we would have had waste because we would probably not have produced these wells. We would have had to drill new wells, and that's a whole economic decision whether you're going to drill those wells or not. So there would have definitely been some waste or the expenditure to drill new wells to get this production.
What does this data demonstrate about the time limits and value of division discretion?
So it's critical, I think, that we utilize the strengths of the division to be able to have discretion over TA'd status of wells. If a well is properly TA'd, it demonstrates mechanical integrity and it has beneficial use, and we can demonstrate that we have a timeline, that we have a proper use for these, and they're not at risk for being orphaned, if you will, then I think that we should allow the division to have that discretion.
And in your opinion, how would Welk's proposed rule result in waste?
Well, for one, we would be plugging a lot of these wells. So then we would have to make a decision whether it was economic or the timeline to drill a new well. It may not be in some cases, so you would have waste. You wouldn't recover the resources that you can recover in an enhanced oil recovery project.
And just to kind of to summarize for the commissioners, what is your recommendation?
My recommendation is that we allow the division to have discretion over temporarily abandoned time limits. That the current way that it's being handled, that an operator proposes and provides the information that's relevant to this, that the division needs to make a decision, and we continue with the current process. I believe it has worked well.
Thank you, Ms. Montgomery. I'd like to move to admit Exhibit C of Ms. Montgomery's direct and rebuttal testimony as exhibits.
I'll pause for a moment in the event there are any objections. Exhibit C is admitted.
Thank you. We'll pass the witness.
Thank you. Ms. Fox or Ms. O'Grady?
Yes, thank you so much. Just a short set of questions. Good afternoon, Ms. Montgomery. My name is Morgan O'Grady. I'm an attorney with the Western Environmental Law Center for applicants. And I am going to pull up a slide in just a moment. Ms. Montgomery, are you familiar with applicant's expert Tom Alexander's testimony?
I was not able to listen to his testimony. No.
Okay, so you're not familiar with the graph before us on the
No,
screen?
I've never seen it before.
This graph shows data demonstrating that wells on average across all operators in New Mexico within a certain range of time that's identified at the bottom of the page. It shows that wells on average tend to not come in back into production after a certain amount of time. And my question to you is, do you have any data, and specifically, do you see on the screen that 99.5 of the sampled reactivations occurred within 8 years?
I mean, I see it written, well, I don't see 99. I think I see 90+% on this particular, are you asking if I can see it? Oh, 99, there you go. 99% of the sampled thank you for that.
Yes,
occurred within 8 years. Okay.
And do you agree that the 7 years plus 1 year of inactivity come out to 8 years of time in the proposed rules that a well can remain inactive?
In the
Or
proposed
NTA?
rules? Sure.
Yes.
Yes.
Does Oxy have any data? I'm aware that that you have presented testimony on various wells of Oxys that have come back into production after much longer periods of time in association with, for example, EOR projects. Do you have any data on Oxy's reactivations over time?
Other than what I just presented?
Yes.
No, not other than what I just presented.
Do you have any reason to dispute that this data is representative of reactivations across all wells in New Mexico and all operators?
No.
Okay.
I have no idea where his data came from, so I have no basis for that. I can just tell you what Oxy about our data.
I understand. Okay. I'll conclude my questions there. Thank you so much, Ms. Montgomery.
Thank you. Mr. Tremaine or Mr. Hall?
Thank you, Madam Hearing Officer. Just a couple of questions. Hi, Ms. Montgomery. My name is Michael Hall. I'm an attorney with the Oil Conservation Division. Nice to meet you.
Nice to meet you too.
Now, I have a couple questions specifically about Oxy. Are you aware whether Oxy had in excess of 100 wells that produced less than 90 barrels of oil equivalent in fiscal year 2024?
I think I heard that when you were talking with Miss Wallace earlier, but that would be my only knowledge of that.
Do you have any reason to dispute that?
No, I don't.
Oh, okay.
I just don't have the
Um,
data in front of me. No.
Are you aware of significant downhole mechanical reasons why Oxy would have so many wells producing so little petroleum?
Well, if you looked at the slide that I showed earlier, the early, we had some wells in Hobbs that were very, very low producing. I don't know how low, I mean, pretty low. And once we started enhanced oil recovery, they just took off. So there was definitely value in those wells that had very low production that were part of an enhanced oil recovery project.
And so with those wells in particular, would you assume that there were not downhole mechanical issues since the project was so successful?
Or they were fixed. Yes, I don't know of any downhole mechanical issues with them.
If there are no mechanical issues, and these wells that I asked you about earlier, is there a reason Oxy couldn't produce those for 180 days instead of say 90?
There could be a various number of reasons. Sometimes you get shut out of a pipeline and you're trying to keep wells on as you're negotiating pipeline or as the plant is doing a turnaround. That's one that's very common in West Texas and New Mexico that I know of offhand.
Nevertheless, if you were able to double the production days, you would expect the production values of any particular well to increase. Isn't that right?
Meaning if the well is on for more days, it would have more production?
Yes, ma'am.
Is that kind of what you're asking? I would assume so.
Okay. Are you aware that Oxy, between its two O grids, has 45 wells that produce less than 10 barrels of oil equivalent in fiscal year 2024?
No, I'm not familiar with that. I'm not disputing it, but I'm not familiar.
Okay, fair enough. Are you familiar with the Sand Dunes 34 federal number 3 well?
No, I'm not.
Okay, I'm going to share my screen here. If I can. Okay. Do you see that, Miss Montgomery?
Yes.
Okay. I'm gonna.
It says plugged
on-
site released. So this is a plugged well, right?
Yes, ma'am. That's my understanding.
Yeah.
So, and if I'm not mistaken, well, you can tell me, but it looks like. Can you tell from this production data when it was likely plugged?
No. Well, I guess there's a little bit in 2024. Yeah, it looks like there might have been a bit in 2024 just from looking at your screen.
So it's 2025, but from that, it would either be 2024 after the 16 days of production or 2025 where there's no production in volume or days, correct?
That's what it looks like on screen.
Okay. I'll just represent to you. This is from OCD's permitting. It's the well specific query for this well we're discussing, which is an Oxy well. So do you have an explanation or theory as to why over those last 5 years before the plugging, only 72 days of production and only 5 MCF over that time period from 2021 until the plugging this year?
So
I'm gonna
without knowing
object-
this,
I'd like to object here. I think this is a little outside the scope of Ms. Montgomery's testimony.
Mr. Howe?
she specifically pointed out specific Oxy wells to kind of go over her theory, and we're just exploring that a little bit to discuss the overarching reasons behind Oxy's position with regard to the rules.
All right. So Ms. Montgomery, if you can answer the question, great. And if you don't know, that's fine too.
Okay. Well, with respect, my testimony is about TA'd wells having the discretion of the division to bring them on for good cause, and I showed some good cause. But looking specifically at this well, I don't know the specifics of this particular well or why the production shows as it does.
Would the fact that it's plugged indicate to you that it was no longer capable of being economic for Oxy?
Oxy chose to plug this well, so I'm assuming they decided, well, it could be no beneficial use. It could be they decided that the wellbore had too many issues. I mean, I don't know the actual reason they plugged this well, but it didn't have a lot of production, so obviously we plugged the well for some reason.
And this is kind of the crux of why I'm asking about this. We're talking about time frames, correct?
For TA'd wells and
for TA'd wells,
yeah.
we're talking about reasonable time frames. Any reason this well, it took more than 5 years given those production values to plug it?
I don't have knowledge of this well.
Okay. Now, there's been some discussion about, well, I'm going to pull up Mr. Rankin's famous statute. If I can, excuse me. Well, I don't think that's working. Have you? I think I noticed you've watched some other testimony in this hearing. Is that right, Ms. Montgomery?
Only Miss Wallace's testimony.
Okay. Are you familiar with TA bonding in New Mexico?
No, I'm not. I mean,
You don't have
I
it?
know I've heard of it because I listened to Miss Wallace's testimony, but I'm not familiar with the rule in particular.
Okay. Are you familiar that in the event that a company or an operator has in excess of 25 TA'd wells, that there's a provision for $1 million in blanket bonding?
Not until you just said it. No, I have not been involved in the bonding of this with this hearing.
Fair enough. I'll pass the witness. Thank you.
Okay, thank you. Mr. Moore, do you have questions?
I have limited questions, Madam Hearing Examiner. Thank you. Good afternoon, Ms. Montgomery. My name is Richard Moore. I represent the Commissioner of Public Lands and the State Land Office in this proceeding. Thank you for your testimony today. I'm going to share my screen quickly. So in the applicant's proposed amendments to the definitions, expired temporary abandonment or expired temporary abandonment status means the status of a well that is inactive and has been approved for temporary abandoned status in accordance with 1915-2513, but no longer complies with 1915-2512 through 1915-2514. Do you know, is there does the OCD in their permitting have a status of inactive for wells?
In their, you mean, so in their permitting, you said, I mean, what do you mean as?
I guess is that a status that OCD applies to wells?
Yes.
When you, I guess what I'm asking is when you look up a well, is inactive a category that the well can be described in?
I'd have to look that up. I mean, we know when I think now you're going to catch me a little bit. I think I've seen an expired temporary abandonment status. I believe it's called inactive because we know after a certain amount of times it'll show it as, I believe it's called inactive. I don't know if that's exactly what it's called, but we know when it's been inactive for a certain amount of time after the year or 15 months.
And do you agree with this definition as proposed by the applicants for expired temporary abandonment?
So without looking at exactly what the 1915, 25, 13, and 14 are, I believe this question was asked by Ms. Wallace, so I can defer to her answer. If she agreed with it, then I agree with her. I just don't know all the details of some of the references. I apologize.
That's all right. Do you think it would be sufficient to define expired temporary abandonment as the status of a well that has been approved for temporary abandonment status in accordance with the regulations, but no longer complies with those regulations?
Yes.
Without reference to inactive in the definition itself.
Yes.
I believe that is all that I have for questions. Thank you.
Thank you.
Thank you, Mr. Moore. Ms. Unasi, are you with us? Mr. Maxwell, do you have questions of Ms. Montgomery?
No questions, Your Honor. Thank you.
Thank you. Mr. Sayer? No. All right. Mr. Swazo?
No questions from Namoga, Madam Hearing Officer.
Mr. Cloutier?
I don't have any questions of Ms. Montgomery, Madam Hearing Officer.
Thank you. Mr. Tucker, do you have any redirect?
Just a couple questions. Thank you. Ms. Montgomery, you were asked some questions by counsel for WEC regarding a graph prepared by Mr. Alexander. Is Oxy the applicant in this proceeding?
No, we're not.
Is Oxy proposing to place a cap on the timeline for temporary abandonment status?
No, we're not.
Is it Oxy's burden to provide data supporting the rule change?
No, it's not.
Okay, thank you. Just a couple more questions. Counsel for the Oil Conservation Division asked you some questions about a specific well. Was that well part of the wells included in the graph that were returned to production in the Hobbs area?
No, it was not.
Thank you. No further questions.
Thank you. Commissioner Ampoma?
Yes, I do have few questions. And if we can bring back the slides.
Yes, one moment.
Thank you. Yeah, let's start from slide number 2. Thank you. Yeah, so you were asked about if you are aware of any deficiencies in this existing rule, that cause concerns with the integrity of wells in approved TA status. And I presume I recall that your response was no. Is that correct?
That's correct.
Now, my follow-up question on that will be, I'm not sure if you were able to listen to some of the OCD witnesses.
Unfortunately, I was not, so.
Okay. Based on their witness statements, they talked about all the issues that they have with the current rules. One example was they talked about 25% of operators have not reported production for some years now. So don't you believe that the current rules, the proposed rules, will more or less give OCD the flexibility to more or less work with these companies to bring them into compliance?
So if I understand, I'm trying to understand which all the proposed rules, or what are we talking
Okay.
about?
Yeah, let me expand on that. So let's say with wells that have not reported production for several years.
So not
And
necessarily TA'd wells, it's just inactive wells.
Exactly,
Is that
exactly.
okay?
Exactly,
Okay,
exactly.
got it.
So don't go ahead, please.
No, please.
Yeah, so my question on that one is that even for that simple example that we just went through, don't you believe that the definition of beneficial use and then even TA wells and all of that will give OCD the opportunity to really go in there and work with these operators to bring them to compliance, or more or less TA the well?
So I think Oxy in general agrees with a lot of it, and we've worked with WELC on the proposal, and I would have to stand by Oxy's red lines on that for what we agree with on helping the OCD bring these wells into compliance.
Yeah, let's go to your slide number 9. Yeah, and thanks so much for bringing the slide, because I'm also a firm believer that wells go through numerous production cycles, the primary, secondary, and then the tertiary. Oxy's case, let's say it will be a great example, but my question to you is, do you have some other examples of operators that have gone through this type of cycles over the years?
My experience has been with Oxy. I do not, and this is a great example, and we had it in Hobbs, and it's very timely, but I could say that we have whole divisions in our company that are looking at different types of enhanced oil recovery that will be applicable to many different types of wells. And so seeing the great response we have here in some of our pilot projects, we wouldn't want to have to drill a new well or plug the well prematurely if we can demonstrate that this well will have beneficial use. And we're not, we would definitely have to demonstrate that. And that's something that we would be prepared to do and think we should be prepared to do.
Now, based on all the discussions that we've had for let's say a week now, don't you believe that your concerns of OCD more or less having flexibility on TA well administration has been addressed some way, somehow?
In testimony that it's been addressed?
Yes, especially through the exceptions that has been proposed.
I believe I haven't heard all the testimonies, so I apologize. And so I'll have to just step back to as long, just knowing that we have the division has some flexibility, like we have proposed here and Oxy has proposed in the red line. That's really what I'm asking. I'm not trying to avoid the question. I'm just not exactly sure because I haven't listened to all the different testimony. But what we've talked about here, that's exactly what we would propose as Oxy to give us some the division, some flexibility on the TA'd wells for good cause.
Thank you for your time. Do you not have any questions?
Thank you.
Thank you. Commissioner Bloom, do you have questions of Ms. Montgomery?
Yes, thank you, Madam Hearing Officer. Good afternoon, Ms. Montgomery. Thank you for your time today.
Thank you. Good afternoon.
And if we could we go back to that slide again that we were just looking at? That'd be helpful. Thank you, Mr. Tucker. I appreciate that. Pull up my question here. Ms. Montgomery, I appreciate your thoughtful testimony today. Yeah, I think as Dr. Ampoma stated, and I don't think it's lost on any of us up here that these wells can be resources. And of course, Oxy and many other operators see wells in TA status and think resource. And from the OCC lens, and from the lens of the land office, we may also see resource, and a lot of times we see a resource there, but we also see risk. And that weighs on us because we have a responsibility to the state and to ensure public health and protect the environment. And I think there's some waste issues in the balance here as well when wells are not produced for years and years or a very low production. Mr. Alexander's data shows, I think you saw what the applicants put up just a little bit ago, that 98.5% of wells are back in production after 6 years. And under this rule, you have 8 years. And so I look at this graph and see oil production really dip around, zoom in a little bit here, 2009, 2010. And by 2015, 2016, obviously you'd taken matters, you'd begun working on this Hobbs EOR project. And right about 7 years, 8 years, we see oil production increase. I mean, does this speak to some ability that Oxy would have to be able to work these sorts of wells and turn them around before 8 years?
So, Oxy's known for EOR. We're the biggest EOR operator in the world. So this is what we do, and we're very familiar with it. I'm not sure all the other statistics take into account EOR, which is why I really wanted to testify today to show what can be done if we use EOR. And so the ability to be able to bring our case and show when we have definite plans that we're working through and have that taken into account and have the division be able to have some discretion, that's really my point here. With what I'm doing, and I'm not sure I exactly answered your question. Can you redirect me if I did not?
No, I think you did just fine. It was
okay.
It was more of a statement than a question, really.
Okay.
And I appreciate that. And certainly, when I think of who's doing EOR in New Mexico's Permian, I think of Oxy, of course, and see a company with resources that take some dismally producing wells and turns them around, and all of a sudden those wells are producing a couple 2,500 barrels a day. That's significant, and we have a mandate to produce value for our landowners, our beneficiaries, the school kids in New Mexico, and weigh that against risk. And of course, I see a company like Oxy and think, this is one of the companies I would be, less concerned with than many others that we have. But the point of the value of these wells is not lost on me. So Ms. Montgomery, thank you for your time and testimony today. I think we've kept you up late if you're actually in London there. So thank you
I
very much.
am. Thank you.
All right, take care.
Chair Chang?
No questions.
All righty. Any reason not to excuse Ms. Montgomery? Thank you very much, Ms. Montgomery, for your testimony.
Thank you. I appreciate the opportunity. Have a good evening, everyone.
I think we move to NMOGA at this point, Mr. Suazo.
Sure. Thank you, Madam Hearing Officer. Let me pull up some slides. NMOGA is going to make its opening statement and then call its first witness. All right. Well, good afternoon, Commissioners, Mr. Chair, Madam Hearing Officer. My name is Miguel Suazo. I am with the law firm Beatty and Wozniak, joined today by my colleague, Jacob Everhart, and we are energy and natural resources attorneys. We focus primarily, especially in proceedings like this, on the regulatory side of the energy space. And it's our honor today to be here representing the New Mexico Oil and Gas Association, which, as I'm sure you all know, represents operators, large and small, who provide the infrastructure to the energy backbone of New Mexico's oil and gas industry and help support the state's general fund. Now, NMOGA's members are committed to operating responsibly, safeguarding the environment, and keeping New Mexico the national leader that it is in energy production while supporting the public institutions that make our state thrive, institutions that myself and my colleague have both benefited from as native New Mexicans. Now, this proceeding is an important one. It is one of the most significant rulemakings that we've had in New Mexico in a long time. And I feel like the applicants that brought this proceeding are well-intentioned, and the division who's supporting this proceeding has some very clear concerns that we've been educated about as this proceeding has gone forward. We've learned a lot already at this stage in this proceeding. However, NMOGA and its members have some very significant concerns about what's proposed. And I think that the crux of the issue is not the what, it's the how and the why about the regulations that are being proposed. Now, applicants have asked the commission to define beneficial use and marginal wells, to expand the financial assurance requirements that operators must maintain to operate in New Mexico. And they have specifically asked the commission to authorize increased financial assurances. Now, we've heard the division say that there are certain issues in this proceeding that they do not feel they can compromise on. And one of those things was Deputy Director Powell said, we want to decrease the 15-month to 13 months. We heard that, understood. Well, from industry's perspective, there are certain areas where we are willing to work with the parties and with the commission to make sure that the rules that are put in place make sense, not just today, but over the long term. But one of the areas where the industry feels that we are on solid footing is on the authority of the commission and the division in terms of what they're able to adopt statutorily. Now, there's been back and forth in this proceeding. We're looking forward to you all hearing from our legal witnesses and their interpretations. There's motions in front of the commission about that statutory authority. And it's one thing to read the statute, as some folks in the proceeding have done. It's another thing to understand the legal case law behind the interpretation of that statutory authority by New Mexico's courts. And we look forward to presenting those arguments and findings to you so that you can make an informed decision about what the commission is and is not able to do for purposes of addressing the issues that are so critical to this proceeding. Now, I think one thing that we've learned so far is, it's been presented as an orphan well crisis. And Welk presented, 60,000 wells that are going to ostensibly cost billions of dollars. But I think it's important to remember that those costs are going to be met over time by industry and the public and other parties that are stakeholders in this whole process over a long duration. But I think what's really critical is that OCD's testimony has really allowed us to focus on what they are concerned about. And those are, as they dub marginal, high-risk wells and high-risk operators. Industry's heard that message. And one of the things that has been brought to the fore in this proceeding is a report from the Legislative Finance Committee. And I'm glad that it has, because I think there's really important information in that report. And if there's one thing that this commission should do, that I urge you to do, is to read that report in its entirety. Because the information and data in there, I think, can be used to help inform the regulations that this commission ultimately adopts, and that hopefully industry and applicants can ultimately live with. You know, I think that a lot of these proposals have the potential effect to really impact the smaller operators more than some of the other operators. And as somebody who's worked in New Mexico economic development for years, I can't think of another time when a government entity would pass a rule that impacted New Mexico's small businesses. Now, that's not to say that they shouldn't help protect and steward the environment and operate in a responsible manner, but jobs are at a premium in a poor state like ours. And I think that should also be brought to the fore and considered as part and parcel of the consideration of these rules. Now, you're going to hear a lot, and you have heard a lot, about whether or not industry was involved in this process. And as best as I can tell, I think that the origination of applicants and OCD's assertions that industry was involved stems back to, I think, some statutory negotiations. Well, this is not a statutory proceeding. This is a rulemaking, and those are two very different proceedings. And I think that it is fair and it is accurate that NMOGA and industry were not made part of this rulemaking proceeding and the lead up to it until just before it was filed. And so I would ask that the commission appreciate the perspective of NMOGA, not that you have to agree with it, but understand where our members are coming from, that we did not get the input into these rules until just before it was filed. And I think that's unfortunate because we have learned a lot to date. And I think that industry is getting to the point where we can offer some informed feedback about what is being proposed. And that is where we're going now with the start of our case in chief. And I am really excited for you guys to hear from our witnesses. We have some of the foremost experts on the issues that are before us. And I want to offer them, you know, originally coming into this proceeding, we thought is going to be more of a critique of these rules. And to be sure, we are going to critique these rules. But our witnesses are also going to help inform the commission on how these rules can be made more effective, more practical, and more meaningful. And that's important because the only thing worse than a rule is a bad rule. And at the end of the day, whatever this commission decides to adopt, it is the regulator, the division, and the industry that are going to have to live with those rules that are adopted for the long term. And we want to make sure that those rules make the most sense from an operational and administrative standpoint. Now, you're going to hear from our first witness, Dan Arthur, who has decades of experience across a range of oil and gas issues. And he's going to touch on the really critical concerns and provide valuable feedback that the commission can use to inform the rules that it ultimately adopts. We're also bringing an actual surety expert, a person who's actually issued bonds and reviewed bonds and lived the life in issuing these financial assurances that operators must secure to operate across the nation. And so we're looking forward to him helping you understand the unique financial assurance framework that exists in New Mexico in a world where there's non-cancelable bonds and also state and federal issues that must be contemplated in addition to, you know, the issues that the OCD considers every day. It is our hope that at the end of our case in chief and at the end of this proceeding, that the commission will adopt risk-based and market-sensible regulations that industry and the commission can live with now and over time. And finally, I would like to say that NMOGA considers itself a partner with the commission and the division in this process. We're here to help inform your decisions because we want to have a thriving oil and gas industry. We look forward to presenting to you our witnesses and our evidence, and we look forward to working with you on a collaborative solution that will make sense for New Mexico now and over time. Thank you.
Thank you. Mr. Swazo, we're kind of in an awkward place, an hour from lunch break. So it occurs to me that either your witness could do about half and then we could take a break, or we can just take a short break now. What would you?
He's going to be a long, lengthy witness, so I think if you want to take a break now, that makes sense.
Okay, let's just take 10 minutes now. All righty. Let's come back from the break, please. We are back after a short break. I see a witness. You're Mr. Arthur? Hello, would you spell your first and last name for the transcript, please? Or state
Now,
hand.
am I
Well
here
done,
now?
John.
Can you hear me?
You
Okay.
are. Do you swear or affirm to tell the truth?
I do.
Thank you, Mr. Swazo.
Thank you, Madam Hearing Officer. Mr. Arthur, good afternoon. How are you today?
Doing good.
You know, it might amuse you to know that when I was reviewing your slides, my 3-year-old walked in and jumped on my lap and thought I was looking at the ABCs.
Okay, maybe.
So, Mr. Arthur, thank you for being here today. If you can please, let's go to slide 2. We're going to start with your direct testimony, and we want to talk to you about your role and your purpose in this proceeding. Can you please state your name and your role in this rulemaking?
My name is Dan Arthur. I'm the lead witness for NUMOGA. My purpose here really is giving an overview of NUMOGA's position and for this, and also to really kind of set some ground basis for the other experts. For myself, I am the lead technical expert. I've testified on more than 2,500 dockets across the country, more than 100 different litigation cases from federal, state, county, et cetera, including the pit rule in front of the commission. I'm a registered professional engineer in 36 states, including the state of New Mexico, registered professional petroleum engineer, certified petroleum geologist, a bunch of other stuff. Used to work for the US EPA, was an expert with EPA in the UIC program, done lots of different things that the slides go over here.
And we won't spend time on all of the slides, but just for the commission's knowledge, he has an extensive background, and I want Mr. Arthur to really focus on kind of the scope of his testimony. Let's go to slide 8. So, Mr. Arthur, did you file direct testimony in this case?
Yes, I did.
What was the scope of your direct testimony in this filing?
It really comes down to 7 general issues here. One is the new definition of beneficial purposes or beneficial use and related proposed presumptions of no beneficial use. Changes to when wells are to be either temporarily or permanently plugged and abandoned. Amendments to New Mexico's existing temporary abandonment program. New definitions of marginal well. The increased $150,000 individual financial assurance requirements, removal of the blanket alternatives and other financial assurance changes, changes to waste prevention requirements, and new requirements for operator registration and change of operator, essentially.
Thank you, Mr. Arthur. And I'd like to start at the outset with your conclusions in this proceeding, and then we can get into kind of the justifications and rationale behind those conclusions. Can you please share with the commission the conclusions that you reached and what you reported at the end of your direct testimony?
Yes, sir. And I'll apologize up front. We have a number of things to go to. These conclusions are very high level, but as I think a good introductory, the applicant's proposals are, in my opinion, and this is 45 plus years of experience, are overly rigid, operationally impractical, and economically disruptive. The proposals discredit the value of and disproportionately impact marginal wells. A risk-based financial assurance regimes that reflect factors such as well depth compliance, history, condition of the well, all that are really a better balance and make more economic sense and stability. The commission can ensure that its rules remain both enforceable and aligned with technical and economic realities of modern
oil and gas development in the state, preserving the regulatory discretion that it currently has, maintaining the 5-year term of temporary abandonment, and other things. But
Thank you. Let's move on to the subject of waste, slide 10. What are your overarching concerns with the proposed amendments and additions proposed by applicants and supported by OCD with respect to waste?
I've dealt with this issue many times over the last several decades, and worked with many of the state oil and gas directors and companies, and just the concern of with waste and premature plugging of viable wells that once plugged are lost forever. When technology to utilize these wells exists, and there's so many examples of wells going on for many years. The applicant's proposal will either directly or indirectly result in premature plugging of otherwise potentially economic wells and units. And it's significantly here, in my opinion, it's the state of New Mexico's responsibility to protect and effectively use its natural resources. Premature plugging could mean that those resources are lost forever, similar to what Oxy talked about. Had they plugged those wells, that EOR project may never have occurred.
Thank you, Mr. Arthur. Let's move on to slide 11, which goes over the new definition of beneficial purposes and use and the related presumptions of no beneficial use.
You want to go to the next?
Yeah, slide 12, please. So let's start with applicant's proposal to define beneficial use or beneficial purpose and create a separate presumption of no beneficial use provision. What would applicants define beneficial use or purpose as?
So this one is very concerning to me, but beneficial use is an oil and gas well that is being used in a productive or beneficial manner, such as production, injection, or monitoring, and does not include the use of wells for speculative purposes. And this is tough for me as a petroleum engineer. As a petroleum engineer, I'm the only engineer there is that never gets to see what I built. I don't get to see a building, a bridge, a road, a street, any of that. We have to use the data that we have to think about how things are underground. And when I look at beneficial, I've done work, including working with OCD, BLM, others, on best management practices, beneficial use of produced water, and so forth. That idea of what beneficial is tough. And then speculative purposes, if this is the oil and gas industry, we do all that we can, but we still speculate, not using some silly dictionary definition that was proposed by earlier witnesses. But we do the best that we can, and we speculate. If we didn't speculate, we'd never have a dry hole, right? I mean, it's just that we're trying here, and this isn't waving our arms. This is the industry doing everything it can. So that term speculative really bothers me.
Thank you. Let's move on to the next slide to continue with this issue. Can you tell us, what's reflected on this slide?
So New Mexico has historically extended beneficial use beyond volume-based thresholds or narrowly defined productive activities. And historically, OCD has recognized the various variety of beneficial uses, using on lease fuel, equipment power, et cetera. But many of these functions are essential to field development and compliance, and are not speculative. Even though they might seem speculative, inclusion of the term speculative as a disqualifying factor without definition introduces so much subjectivity and regulatory uncertainty and so forth. It's just very much of an issue, and risks of introducing duplicative standards is just tough with enforcement and many things.
Thanks for that background and insight, Mr. Arthur. Let's move on to slide 14. Can you explain to the commission your recommendation on beneficial use?
Well, I would say do not define beneficial use, otherwise reject the exclusion speculative purposes from any adopted definition. So adopting the proposed definition would likely result in misclassification of viable wells, and in my opinion, increased plugging obligations, associated loss of production and tax revenue. recommend rejecting adding the new defined term of beneficial purposes and beneficial use. You know, in the event the commission proceeds with this, I would totally reject the speculative language. And we have another expert that's coming in later that will be talking a little bit about some options for the commission to consider.
Very good. Let's move on to slide 15, which is the related new presumption of no beneficial use. Can you walk the commission through your understanding of that proposal?
This criteria is really this, you know, presumes that, production well is not capable of beneficial use if triggered during any consecutive 12-month period where, you know, less than 90 days of production, less than 90, BOE, and a similar one for injection wells. There's an exemption, period for wells drilled and completed. But the procedure that makes presumption rebuttal, this is tough.
Okay, let's move on to slide 16. Which sets forth the sole application process to refute the preliminary determination. How would this presumption work procedurally, and does it create a reasonable and meaningful way for operators to rebut that presumption in your view?
So, in this, a well or wells not being used for beneficial purposes would have 30 days to apply for administrative review. 30 days is tight for any operator, but application, not to mention the division looking at this, but application for PD review would required to include operational and financial documentation, forecast demonstration, current or future production, a lot of information that takes time to get, that may not even consider all the things that should be.
All right, let's move on to the next slide. What are your recommendations with respect to the proposed presumption of the no beneficial use provision?
So I would say to wholly reject the rigid 90-day criteria. And again, as I noted earlier, keeping flexibility and so forth is good. If the presumption must be adopted, extending it to 12 months, 3 years, 5 years. 5 years would be aligned with the maximum ATA approval period, and that would make more sense to me. If the presumption must be adopted, I would make sure that we account for documented infrastructure plans and delays. We had discussions about why did it take 8 years, and you think you're completely redoing an entire oil field with water infrastructure and all these pumps and equipment and so forth. And permitting. It's a lot. Projected use with defined field development plans, monitoring data, a lot of different things that just don't happen overnight.
And I'm glad you brought that up, Mr. Arthur, because I think the next slide deals with the risks and potential impact of ignoring how wells can be used strategically. What are the risks and potential impacts of ignoring the strategic use of wells within the industry?
So some of the risks that I see is that this 90-day criteria, it's going to disproportionately impact smaller operators. They're not going to be able to move as fast. We work with a lot of small operators, and it takes time. It's going to discourage incremental development, possible loss of leasehold rights or disruption of unit agreements, and it's going to promote premature plugging of viable wells, which again is a waste. But using the 90-day criteria to determine whether a well is capable of beneficial use ignores operational value and non-productive but regulatory infrastructure-related functions. Leasehold maintenance, reservoir management, environmental compliance. There's a lot of different things that operators and the OCD need to consider here.
Okay. Let's move on to slide 19, which discusses the risks and potential impact of tying beneficial use to production. What are the risks and potential impact of tying beneficial use solely to well production?
So production can vary due to market, seasonal, infrastructure factors like pipeline takeaway capacity, gas plant downtime. I'm dealing with a project right now where a gas plant shut down and 150 wells are shut in. Wells awaiting recompletion, refracs, reactivation, artificial lift systems. I mean, it's like you want an engine right now with all the AI stuff going on. It takes forever. Limited wells capacity for beneficial use to production volumes is short-sighted and doesn't account for the complexities of the oil and gas industry and operators, particularly with marginal wells and shared infrastructure.
And importantly, is it your understanding that if this 90-day criteria is triggered, the presumption results in a preliminary determination, which if not refuted becomes a determination that a well is not capable of beneficial use, correct?
That is my understanding.
Okay,
I'm not an attorney, but that's my understanding.
fair enough. Let's move to slide 20, which deals with the proposal to change when wells are to be properly P&A'd. And this is in 1915-25-8 NMAC, which sets forth when plugging and abandonment obligations are triggered. And on the next slide, slide 21, can you please walk us through the current framework for when a well must be either temporarily abandoned or permanently plugged?
So the applicants propose shortening the action deadline from 90 days to 30 days. Modifying the requirements to place wells in approved temporary abandonment within the compliance window instead of requiring the operator to apply to do so within the new 30-day time frame. And they strike the word continuously from the definition.
Okay. And is it your understanding that a determination of no beneficial use is one of only 3 triggering events that create a legal obligation to P&A a well?
Again, I'm not an attorney, but that's my understanding.
Let's move on to slide 22. What are your concerns with changes proposed to when wells are to be temporarily or permanently abandoned?
So I've plugged a lot of wells and work in that space very actively now. But the changes are contrary to actual timelines for plugging and abandonment. Typically, once a decision is made, it may take from 6 to 18 months to get a well plugged. From internal review, cost estimating, contractor mobilization, permitting, scheduling. And a lot of that's going to depend on the depth of the well, site conditions, access. Timelines can even extend further, just like we had the example of the owl in the wellhead earlier, but surface access issues, other things. These timeframes can represent minimums. Often there's other requirements, weather, wildlife, floods, fires, all sorts of different things.
Thanks, Mr. Arthur. Let's move on to slide 23. Did you submit direct testimony on the applicant's proposed changes to New Mexico's existing temporary abandonment program?
I did.
It was under 1915-25?
I did.
Okay. And would you like to adopt that here verbally?
Yes.
All right, let's move on to slide 24. Can you briefly just walk us through what's on this slide with approved temporary abandonment?
This is, again, just, the changes would require operators to justify a well's future use to obtain approval from OCD. It imposes excessive and burdensome documentation requests as part of that process, and it limits the ATA status extensions beyond the initial approval period of 2 years.
Okay, and next slide, slide 25, which deals with 25.13 pertaining to demonstrating mechanical integrity. Can you please talk to us a little bit about that?
So this is significant because it changes what was once a notice to now a request, and requires cross-references and demonstration operator will, that the well will be used for beneficial use and improved TA. It increases casing requirements.
Okay, and next slide, slide 26, which also deals with mechanical integrity. Can you please explain the significance of this slide?
Sure, and I apologize. I'm trying to go at quickly and a high level here just to run through these, but again, once what was a notice is now a request, requires cross-reference, a demonstration of the operator that the well be used for beneficial use with approved TA status and so forth.
Okay, and I think, moving on to slide 27,
yes,
28, I think that, what you're trying to say here is that these definitional changes were characterized as clarifications but do you consider these changes to be mere clarifications?
I do not.
Can you please walk us through that, starting with slide 28?
So this is adding a new single definition for expired temporary abandonment and expired temporary abandonment status as proposed here. And I think I go through more detail on the next slide.
Okay, let's move to the next slide. So you submitted direct testimony regarding the proposal to add a definition of beneficial use or purposes and the related presumptions. What other definitions and related proposals will promote waste and will result in premature plugging in your view?
This definition proposal of adding a new definition for marginal wells and increase their financial assurance obligations.
Okay. And moving on to slide 30, what is the proposed definition of marginal well?
That an oil and gas well that produces less than 180 days and less than 1,000 barrel oil equivalent a year within a consecutive 12-month period would be considered marginal.
Have you heard testimony in this proceeding proposing to lower that amount from 1,000 to 750 or maybe even lower?
I haven't been on all the watching everything, but that's my understanding based on reading some of the stuff reading the testimony that may be a consideration.
And was that what was proposed in the LFC report? Do you recall? Would you believe me if I said it was 750?
Yes, I think it is. I think it is. I'm hesitant of saying absolutely without seeing that right here in front of me. But
would lowering that volume amount make more sense than 1,000 BOE?
It would make more sense, but again, I truly feel that that putting these specific, days and volumes to specifically say what a marginal well is across the board is a little tough.
Sure. Okay, and let's move on to slide 31. What are your recommendations and concerns with the definition of marginal well the applicants proposed?
Based on my experience, it should not be defined, but if it is, it must be grounded in operational and economic context, considering leasehold strategy, reservoir management needs, cash flow projections, not just abstract thresholds. And if it must be defined, then the definition should incorporate flexibility to allow for case-by-case economic assessments, as is done, EPA and other areas.
And do other states address marginal well issues that better align with regulatory realities?
Yes.
Let's move on to slide 32. What would the definition of a marginal well be used for, and what other proposals by applicants, in your view, are implicated here through this definition?
So this deals with revised financial assurance of $150,000 for each marginal well prior to transfer, and more. But this gets down to the per well financial assurance issue.
And would raising these financial assurance amounts impact asset transfers and changes of operators?
Absolutely.
Can you explain why?
So when you have this one tracking it and the things that are in here are tough, but assuring that that's done, assuring that everything is there, this can become a challenge.
Okay, let's move on to slide 33. Still dealing with marginal wells. What is a marginal well producing in terms of volume and value, and why are they important to New Mexico?
I will say that marginally producing wells in New Mexico collectively contribute a meaningful share of the national production. Marginally producing wells represent a significant portions of New Mexico's oil and gas portfolio. Huge losses, financial losses and repercussions, including lost tax revenue, could result if this is moved forward with. And I will also note, this is significant, I think, is marginally producing is not necessarily synonymous with end of life. I know wells that have been producing over 100 years.
Okay. And I think that brings us to, a comparison to some other states and whether or not they define marginal wells. And it's my understanding that not all jurisdictions choose to define marginal well. Is that correct?
That is correct.
Okay. How do applicants propose definitions of marginal wells compared to other jurisdictions that did elect to define the term?
So this is, you have the table here, but like if you look at North Dakota, they have a couple of different definitions. One, less than 10 barrels a day for wells, under 6,000 feet in depth, and less than 35 barrels a day for deep wells in the Bakken or the Three Forks. And North Dakota is a little different because the first oil well wasn't drilled in North Dakota till 1956. And you had the Bakken come in later and the Three Forks. But so you have like kind of really two categories of wells in the whole state. It's very different than New Mexico with the San Juan and coal bed methane and all this other things. So, but there's other ones per state that have looked at this and tried to provide a broader category.
So in your view, are there risks or impacts inherent in adopting a rigid definition of marginal well as proposed by applicants?
That's my opinion.
So based upon all that you've touched on with respect to marginal wells, can you please provide the commission with your concerns with adding a definition of marginal well in New Mexico?
So as noted on the slide, the risk of premature plugging of marginal wells yet viable, it just gets amplified by these financial assurance proposals. So if you look at this on an overall basis, there's serious cost implications for the state of New Mexico and operators alike. If you look at this, some of the numbers here and what percentage of the wells and what they've contributed for marginal wells in the state of New Mexico. And then if you look at just FY 2024, industry contributed 49%, about $7.4 billion of the state of New Mexico general fund. And if you look at the production, of the marginal well portion of that, it's not insignificant. This is, over $1 billion.
Okay. Now let's move on to slide 37, because I'd like for you to discuss for the commission the proposals to increase financial assurance requirements for marginal wells. Next slide. And let's start with slide 38.
So this, I'd say of significance here is the $150,000 per well bond and what essentially ultimately gets rid of the blanket bond approach, but it provides essentially a stacked financial assurance program for marginal wells.
Okay. Let's move on to the proposed financial assurance increases for active wells. What are those proposals?
So the current financial assurance requirements for active wells are risk-based, which I think, the OCD, the OCC states in general didn't do that for no reason. So right now, starting at $25,000 plus an amount determined by depth, and offer tier blanket bonding alternatives of $250,000 is only required to secure 100 plus active wells. The proposed increases for active wells financial assurance requirements of $150,000 per well or $250,000 blanket bond alternative. So the scope of active wells financial assurance requirements change because applicant's proposal would add new marginal well requirements, expand inactive requirements to the scope, and add new grounds to inactive to align with proposed definition of beneficial. So if you start looking at this, and we've heard a lot of testimony over the last few days about it, but in my opinion, it's unworkable and will unnecessarily exponentially increase the bonding requirements for wells which pose the least risk that are most prevalent in New Mexico and will drive business and tax revenue out of the state. Absolutely.
All right, now let's move on to the current financial assurance requirements for inactive wells. Can you briefly walk us through that on slide 40?
So this shows in red what's proposed, but inactive wells and wells in approved and expired temporarily abandoned status and so forth. But this comes back to the $150,000 per well and blanket plugging financial assurance equal to an average of $150,000 per well.
Okay. And then for the next class of wells, which are active wells, had applicants propose amending those financial requirements? Slide 41.
So currently, financial assurance for inactive wells are risk-based. We talked a little bit about that, but proposed financial assurance for inactive wells and wells in temporary abandonment status would be $150,000 with no true blanket bond alternative. So $150,000 well average blanket bond creates a moving target, really, when you look at what wells are being done, especially over time, which in turn creates internal compliance risks. So just like the active well proposals, the inactive well financial assurance requirements are, in my opinion, unworkable, unnecessarily exponentially increase the bonding requirements for wells, which New Moga P&A expert, is going to talk about here a little bit later.
Okay.
But it'll also certainly drive business out of the state.
Let's move on to slide 42. What is the expanded scope of inactive wells that are subject to heightened bonding requirements under applicant's proposal?
So this shows the existing and proposed language, which I won't read, but it could effectively also be expanded to any well which has had no production or injection for 12 consecutive months, because OCD separately proposes to modify the definition of inactive well by adding those new grounds to align with proposed new definition of beneficial.
Okay. And moving on to slide 43, dealing with proposed financial assurance increases for marginal wells, and they're tied to the inactive territory. Can you, what are the new requirements and what are your concerns with this proposal from applicants?
So the new $150,000 financial assurance requirements for all individually secured marginal wells would start in 2028. If the new less than 15% threshold, which is very small for marginal or inactive wells, portfolios beginning at $150,000 requirement applies to every well registered to the operator, regardless of active, marginal, inactive. Inclusion of these requirements will exponentially increase bonding and rulemaking. This rigid, unrealistic threshold set by definition, and keeping in mind the prevalence of marginal wells in New Mexico, this will have a devastating impact.
All right, and moving to slide 45. Can you please walk us through your concerns with this proposed change to 1915 8.9A?
So this gets into the note here. Addition is, the operator shall not proceed with any proposed drilling or acquisition until the operators furnish required financial assurance. And again, this is just very difficult in imagine an operator having a number of wells and trying to manage all this, and OCD trying to manage them, managing it, and so forth. This is unworkable.
And is it unworkable from like a timing perspective? Like, what can you help us understand why it's problematic?
I think it's from what you're going to require through through this and many of the other changes is you're going to have more staff at oil and gas companies, more staff at the OCD, trying to manage what stuff's going on, because that's the other thing that doesn't happen is wells aren't typically just a static thing. We're trying to do different things with them, consider them for different things, and so forth.
Thank you. Let's move on to slide 46, which are other proposed financial assurance changes to 1915-89F. How do applicants propose to change the incomplete blanket financial assurance requirements?
So this one gets a little bit more complicated for me, and we're going to have another expert that's going to, a surety expert that's going to talk about this. But this gets down to the consumer price index and updating things as we go along to essentially increase that bonding level.
Okay. And moving on to slide 47, concerning incomplete financial assurance, what are your concerns with these proposed changes?
So the proposal would require operators with incomplete blanket financial assurance requirements provide an additional $150,000 single well financial assurance for uncovered wells and remove the blanket option. This is unworkable to mandate matching new wells with bonding coverage without accounting for acquisitions and issues updating bonds. This is another instance of the applicants eliminating blanket bond alternatives, which we'll have another expert talk in more detail about, but this is concerning.
Okay, so overall, it sounds like there's an overarching concern with a one-size-fits-all approach. You've discussed the $150,000 individual financial assurance. Can you explain why this is problematic compared to a risk-based alternative?
So keep in mind that, as we've had witnesses talk about in the $150,000 looking at data from the OCD, but again, as has also been testified, that industry plugs 95% of the wells, and the current costs seem to be based off of extreme plugging wells, extremely high ones that aren't typical things. And when you look at this, well plugging may cost $20,000 or less for some wells, and even for longer horizontal wells, you typically don't plug the horizontal section. And moreover, an operator doing this, we just plug 2 wells, were unconventional horizontal wells in the Texas Permian, just across the border. And by the time we sold the tubing, cut the casing, sold that, we're able to plug both those 2 wells for $4,000. So there will always be exceptions, but I think that there's a better, more tailored way to look at this, as opposed to this hard and fast $150,000 based on a few examples.
So you brought up some other examples in other jurisdictions on slide 49. Can you walk the commission through how the proposed financial assurance changes compared to some other jurisdictions?
So again, these are, some, other states, Utah, North Dakota, Colorado, but, Texas, it's right across the border over here. So, the Railroad Commission maintains a pure blanket bonding schedule, $25,000 for less than 10 wells, $50,000 for 11 to 100, $250,000 for more than 100, but, these are things that are not similar to what New Mexico has now. But it varies, kind of by state. All the states aren't the same. They've chosen to do things a little different, but they're also all different. But.
Okay. Let's move on to the next slide, which discusses the risks and potential impacts that could occur if these changes are adopted. Can you walk us through your concerns on that slide?
So sure, there's certainly direct operational impacts of heightened financial assurance requirements on this per well basis. It's going to repeated revisions to bonding instruments, which is going to be an ongoing thing. Legal review of acquisition documents for bonding, delays in closing deals, higher overhead, and so forth. But but it'll likely require expanded internal compliance staffing, as I noted earlier, and other unintended consequences, I think, that are going to flow from this is reduce access to capital for small and mid-sized operators, discourage participation from asset acquisition or farm-in agreements, premature plugging. But even, even from the small operators, you're going to have large operators that aren't going to be able to take assets and provide them to maybe a smaller operator with lower overhead that could really turn those assets into something great.
And you've experienced changes like this and their impacts, in other jurisdictions. Can you please, on slide 51, walk the commission through some of the negative effects that have been experienced by other states as a result of changes such as this?
Well, certainly the three that I show here, in California, excuse me, implemented bonding reforms in 2020, 2022, led to significant higher bonding obligations per well, triggered delay of permit approvals, transactions, contributed early abandonment of marginal wells, and ultimately a lot of business leaving California. Alaska attempted the per well bonding increase in 2019, was ultimately scaled back after industry opposition and concerns about insolvency and stranded assets. I talked to them extensively about this. Colorado did the same thing, and it's led to operator consolidation, divestment of marginal assets, increased bonding disputes, and frankly, a lot of operators and companies that just refuse to do business in Colorado now.
Okay. Now, we told the commission we're going to provide some recommendations throughout your testimony. On slide 52, can you please walk the commission through your recommendations?
Sure. And these, again, we're limited on time, so these are very high level recommendations, but these far-reaching, expansive negative impacts greatly outweigh the incremental benefit the new requirements would provide. In my opinion, they're completely unnecessary considering the level of financial assurance already provided. New Mexico's current financial assurance requirements, as will be explained, here later, so they'll go into some of the details, other experts from NUMOGA. But we also have the state's reclamation fund in place as a backstop in addition to the existing financial assurance, as well as the state's existing TA program, which is going to be talked again. But alternatively, I would suggest engaging stakeholders in technical discussions about the relative risks associated with plugging and abandoning a variety of wells, and to better inform a figure of well instead of this one size fits all. And that's one of the things I really saw about this is we tend to be lumping things in these very, very general categories, this number without considering where the well is, the age of the well, what the potential is and so forth, and what the new potential technologies and available things are for wells to be beneficially used today.
Thanks, Mr. Arthur. Can you, moving on to slide 53, also go over for the commission your conclusions for the financial assurance proposal portion of this rulemaking?
So hopefully my testimony is providing a little context for Mr. Emmerich's forthcoming testimony. I've examined other states' financial assurances, and I find Welk's proposal would be unnecessarily rigid and just doesn't incorporate a risk-based framework, which is critical. So for me and based on my experience, proposed framework fails to reflect the operational and cost variability of well plugging. In my experience, a one-size-fits-all just doesn't work. Some wells can be plugged very cheaply and not for this huge number that's been provided, and that shouldn't just be proposed across the board. They don't account for the fact that vertical well sections of horizontal wells don't necessarily need to be plugged. Disproportionately impacts smaller operators, which I hate. I love small business. I have a small business. And it poses barriers to routine transactions and transferee operators to post excessive bonding amounts and triggering by triggering blanket bond requirements based on marginal well percentage that don't correspond with actual risk.
All right, so let's move on to the next issue we want to, have the commission consider through your testimony. Slide 54, let's discuss the proposed changes to the waste prevention requirements under 1915-59A and how they will affect financial assurance determinations if adopted as proposed by applicants. And maybe if you could start, with what the waste prevention requirements are presently, that'd be helpful. And then we can move on to the next slide.
So from a very basic perspective of where we are now, it's the state's responsibility, just as it is with every oil and gas producing state, to manage those resources responsibly and not let them go. I mean, that's, if you can. And what's been proposed, it removes the compliance buffer for small operators and minor deviations and adds regulatory cross-references to other things like flaring and P&A, that there's a lot of things that happen in the oil industry that aren't necessarily, meant to be bad or violations or whatever. So they're trying to manage those properties.
Okay. And on the next slide, what are your major concerns regarding this proposed change?
So I really, the removal of the 2 to 10 well compliance buffer for smaller operators and minor deviations make it just unpractical and unrealistic. I've been the EHS director on a contract basis for probably 30 different oil and gas companies, and managing compliance can be a challenge, and sometimes it's very, very minor things that come up. But it creates likely risk of good faith venting, flaring. Technical issues will, be treated like just non-compliance when they could be just not significant, and something that could be addressed very quickly. Adding cross-references enables OCD to leverage those separate and distinct requirements for other uses not intended when reference rules were promulgated, and unfairly penalizes compliant operators if they acquire non-compliant entities. And I've done a lot of stuff where I've helped companies that have bought assets that did have non-compliance, and we spent time getting those assets back into compliance.
So just so I understand, based on what you said, the rule is already in the existing regulations. There's no need to cross-reference it for these purposes.
Right.
Okay. Let's move on to slide 57. What are your recommendations for the commission with respect to applicants' proposal to amend the waste prevention requirements?
I truly believe that they should be rejected, but at the very least, removal of the 2 to 10 well compliance buffer should not be touched. And the cross references in the proposal with the precise requirements, do that and have a grace period.
Okay. Let's move on to slide 58, which deals with 1959, the well operator provisions. Can you give the commission a brief summary of the changes that applicants propose to OCD's operator registration requirements? And we can move on to the next slide as part of that.
This gets into the issue of, any operator, person within an operating company that, was more than 25% owner that had non-compliance or was with a company in non-compliance would be a problem and be impacted.
Okay, next slide. Dealing with change of operator.
Yeah, this is similar sort of thing on the change of operator, that person with 25% interest. So that's I would say the crux of this.
Okay. And then the final slide, before we get into the questions, can you please explain slide 61?
So adding this additional disclosure and certification requirements to operator and change of operator, affirmative certification of compliance with all federal and state laws in each state an operator does business, which Numoga and IPAN have jointly challenged. Numoga's expert will talk about, the legal expert will talk about that, but mandatory disclosure of whether, any current or past officer or owners with more than 25% interest were affiliated with non-compliant operators. Is this an annual certifications? This is tough.
Now, from an operational standpoint, let's say you're a larger company and trying to do business in New Mexico, and you're required to meet these requirements, even though you operate in many different states. From a practical standpoint, what are some of the challenges that you see?
Well, any new operator out of compliance with federal, state, laws in any state that does business, the OCD could deny a change of operator if you were trying to move in, but it goes through these different things, and certifications or disclosure show substantial risks that the new operator can't meet plug-in abandonment requirements if that's the case. So this certainly may vary by size of operator and so forth, but probably be more specific to small and mid-size operators, but this is tough because if I'm own 25% of an oil company and the company I have is a month late on submitting production reports, that's a violation. That's non-compliance.
Okay. Now let's move on to slide 63, dealing with prohibiting transfers of non-compliant wells. What is proposed under subsection E of this proposal?
It would prohibit the transfer of non-compliant wells or facilities, unless they're brought into compliance or a compliance schedule is approved.
Okay. Now, it may seem practical to do that, but what are the risks and potential impacts that you see with this proposal as it's proposed on slide 64?
So I'll just say, as I noted earlier, I've done a lot of this, but these requirements are unworkable, if not impossible to meet. The proposal would chill executive and investor mobility by deterring otherwise qualified professionals from serving, requiring affirmative certification of compliance in all states where an operator does business. May seem easy, but it's not. Tracking the historical and ongoing compliance status of entities is cumbersome. This patchwork compliance burden where, technical violations in one jurisdiction, such as a delayed report or something, non-material, could inadvertently trigger consequences that ultimately could drive business away from the state of New Mexico and worse.
All right. So I think we moved along pretty speedily, given the detail in your direct testimony. Let's move on to slide 65 and 66 so that you can walk the commission through your overarching recommendations so that the commission consider that in this rulemaking.
So I have 7 high-level recommendations. First is to reject the definition of beneficial use and related presumption of no beneficial purposes or beneficial use. Then to decline to add the rigid definition of marginal wells and new marginal well financial assurance requirements. I'd suggest to maintain regulatory flexibility wherever possible, to preserve the use of blanket bonds and avoid stacking requirements, to reject the use of average per well blanket bond requirements, encourage adoption of tiered incentive-based structures, and limiting additional reporting and certification burdens. And as we go through these kind of one by one in a little bit more detail, the commission should decline to add the new definition of beneficial, due to the unintended consequence it could have with the commission's state regulations that utilize the term. If in the event that commission does move forward, the word speculative should be removed at a minimum, and preferably non-production related uses identified within the definition. The commission should also decline to add Welk's proposed presumption of no beneficial use. But in the event that the commission moves forward, I would say, changing this 90-day to our 30-day to 90 days, 5 years, would be better and would align with the ATA.
Okay, and let's move on to your second recommendation, slide 68, which deals with the definition of marginal wells and the marginal well financial assurance requirements.
So I would recommend rejecting Welk's proposal to add a new definition of marginal well. If a definition must be adopted, which in my opinion isn't necessary, then a new marginal well definition and resulting classification must be grounded in operational economic context, not abstract thresholds. Applicants' proposed definition of marginal well sets thresholds that do not align with reality of how marginal wells operate and their prevalence in New Mexico. It appears the new definition of marginal wells would also trigger the proposed heightened $150,000 per marginal well financial assurance requirement for every well, where operators have more than 15% inactive or marginal wells. I also recommend the $150,000 one-size-fits-all individual well assurance requirements be rejected, and that a risk-based individual well bonding currently in place be retained.
All right, moving on to your third recommendation, which is to maintain regulatory flexibility. Can you walk us through why that's important?
So using financial assurance as an example, the commission should preserve the discretion in financial assurance determined by allowing for risk-based bonding levels and approaches to consider operator compliance history, maybe well condition, asset maturity, demonstrated plugging costs, things that actually line up to make those numbers real, as opposed to just a flat number. So that, that flat per well bonding requirement, such as $150,000 per well, fail to reflect actual risk or plugging cost variability and will unnecessarily burden operators that are with viable low producing wells.
Okay, and your fourth recommendation, recommending preservation of blanket bonds. Can you please?
So the commission should affirm that blanket financial assurance satisfies applicable obligations for covered wells, avoid rules that outright or effectively eliminate that option, and avoid rules that require simultaneous single well and blanket bond unless there's demonstrated case-specific basis to require both.
Okay. And your fifth recommendation to reject the use of average per well blanket bonds. Can you walk through that?
So the proposal should require blanket bonding based on the proposal to require blanket bonding based on an average of $150,000 per well introduces target compliance standards that are difficult to administrate or audit or enforce. It's going to create confusion and generate unintended consequences for acquisitions, mergers, and internal compliance. I really think the commission should instead retain the fixed blanket bonding tiers that align with industry norms and would simplify enforcement.
Okay, and your sixth recommendation regarding tiered and incentive-based structures, can you please explain that?
So New Mexico could adopt a tiered-based bonding structure that provides reduced financial assurance for or financial assurance obligations for operators who maintain, for instance, strong compliance records, reduce inactive well counts, perhaps actively participate in orphan well reduction efforts. It's already being used in some states, and I agree the orphan wells are an issue that we need to address. But let's look at this in a reasonable manner.
Okay, and your final direct recommendation, limiting additional reporting and certifications. Can you please explain that to the commission?
So the proposed new registration and ownership certification requirements are overly broad, likely unworkable in practice, and risk discouraging executive mobility and capital investment. Any ownership-based disclosure should be limited to current control parties with material decision-making authority and based on known verifiable records. So I know you can go to state websites or whatever and look to see if somebody has compliance issues or not, but it's not that easy.
Okay. And that completes your direct testimony. I'd like to move on to the rebuttal testimony with the time we have left, starting with slide 75. Can you please walk us through your overarching concerns with the applicant's application?
So one, analysis of what the Legislative Finance Committee report actually states and recommends as compared to the applicant's characterization is an issue I have. The applicants mischaracterize marginal, temporarily abandoned, and orphan wells as high risk and difficult to manage with no future benefit. And third, the applicant's proposals ignore oil field innovation.
Okay. Now, let's walk through what the Legislative Finance Committee report actually says and recommends. What discrepancies do you see between what the LFC report says versus what the applicant says it says?
Well, this is what I appreciate when you encourage everyone to read that report from front to back. But the LFC report recommends a lower threshold for low producing wells than applicants proposed under the new definition of marginal well. The report acknowledges the need for flexibility in assessing future potential of wells. It confirms the lack of authority to make marginal well financial assurance category. The report confirms the lack of authority to deny well transfers if determined the buyer is unlikely to fulfill plugging, abandonment, and reclamation obligations. The report recommends a narrower definition of orphan wells than applied and recommended by the applicant and agency witnesses. And the LFC report narrowly defines a narrower definition of orphan well, undermines the applicant's reliance on OCD's master orphan well list, which captures wells beyond those the state has pursued or obtained plugging authority for.
Okay, next slide. Dealing with applicants' characterization. How do applicants mischaracterize marginal, temporarily abandoned, and orphan wells as high risk and difficult to manage with no future benefit?
Well, marginal and active wells tend to be low risk and can be managed without environmental incident. So temporarily abandoned wells can be easily reactivated and lower risk than active producing wells. They don't have flow pumps, everything going on. Marginal, temporarily abandoned, and active wells present future benefit beyond production or injection.
Okay. And on your next slide, oil field innovation.
So these are just some of the things, we've talked about, water flooding and EOR, but CO2 huff and puff projects, stimulating existing wells, carbon capture and sequestration, and so much more.
Okay. Now let's talk about some of the issues you have with applicants and OCD's position that current financial assurance requirements are inadequate. What other factors do you think were ignored in their testimony, and how can you lay that out for the commission today?
If you look at the history and what's happening, I believe blanket bonds function as intended. Industry can plan, abandon, remediate wells faster and cheaper than OCD, undermining applicants and agencies' reliance on LFC averages. And that's not to say that industry's not going to have wells that are going to be super expensive to plug and remediate too, but this is in general. And OCD often winds up taking the worst of the worst. Operators should not be held to a standard or accountable to the public for cost overruns until OCD's procurement system is remediated. This was noted. These seeming, and I'd say across the board, even throughout different states, but analysis of reclamation cost claims and existing SLO lease surface improvement damages, damage bond requirements. We do a lot of these, but they can vary dramatically. The reclamation fund is ignored, and it's there for a reason. It should be used. Multiple statewide economic and policy consequences will flow from the proposed changes. Financial assurance increases actually create the risk of premature plugging. So this is premature plugging of many wells that are viable and hold value for the state.
Okay. And moving on to slide 80, with your recommendations for alternatives the commission might consider, can you walk us through some additional financial assurance recommendations for the commission?
So it would encourage a phased or risk-based assurance increases, flexibility tied to well risk and operator compliance history. So that was one of the things that I saw really ignored is, how are we defining the risk of these wells other than they're not producing or they're marginal? Refining targeted enforcement mechanisms instead of discarding the tools that they already have. Enhanced reporting or certification for inactive wells only, using reclamation fund as designed. I think there's been bipartisan support has been shown for relying on proven value of reserves and other things. So there's a lot that should be considered here.
Okay. Let's move on to the plugging and abandonment analysis and your recommendation. What recommendations and responses would you like to leave the commission with?
So just to recognize that shortening compliance windows and converting periods of inactivity into near automatic plugging or formal temporary abandonment filings removes operational flexibility. So when you start, sequence recompletions, coordinating, gathering, compression, all these different things that can come into play tend to get ignored. And, plugging not tied to actual mechanical or well-specific risks showing a need to plug undermines, the act and conservation mandates by foreclosing an otherwise prudent near-term reactivation paths and pad level optimization. So it's going to result in plugging viable wells.
Okay. And with respect to approved temporary abandonment and the definitional changes proposed, how would those changes affect P&A, starting with the changes to the approved temporary abandonment definition?
Well, I would reject OCD's assertion that the proposed definition expansion simply provides clarity. That framing omits practical effects of collapsing distinct concepts into a single defined status tethered to compliance. As written, the definition would allow temporary abandonment exploration to be equated with broad non-compliance and then cascade into plugging obligations. That is not only clarity, so that's not clarity so much as a definition-driven mandate that automatically converts routine compliance lapses into plugging obligations. So where consistency is needed across parts, harmonize reference without importing new outcome determinative labels.
Okay. And then on your next slide, you discuss expired temporary abandonment. What about those changes to the expired TA definition?
Well, OCD again suggests that this amendment merely codifies an administrative shorthand, but the phrase no longer complies is vague and could encompass anything from minor reporting delays to mechanical integrity questions. So trivial to significant. This would create an automatic reclassification of wells based on incidental or easily correctable issues leading to arbitrary enforcement. And OCD already administers temporary abandonment through the code. By tying expiration to broad noncompliance, the definition would function as an overboard definitional trigger, which it could automatically force premature plugging again on wells that remain mechanically sound and have future development potential.
Okay. Now, on your next slide, you have a recommendation with respect to marginal well. Can you walk the commission through that, please?
So again, adding the definition of marginal well, based on my experience, the proposed definition of marginal well would capture production and productive and viable wells and misclassify them. So many wells that fall below the threshold there serve critical operational roles like lease retention, reservoir management, and so forth, as we've noted. The LFC report recommends that OCC adopt a definition of low producing wells of producing less than 750 BOE annually or about 2 BOE per day. So for these reasons outlined in my direct testimony, the term marginal should not be defined due to the unforeseen and widespread consequences that modifying the term might have. But if a definition must be assigned, I believe at least the LFC report's recommendation threshold of low producing should be adopted if deemed absolutely necessary. And I don't think it's necessary.
Thank you. We're almost done with your slides, but slide 85 concerning the tying of waste prevention requirements to the beneficial and an active well list. Were there any notes on how the proposals were interconnected and related that you want to highlight for the commission as they relate to your overarching concerns with waste?
So the OCD reports the change is needed to be consistent with the changes proposed. By tying this directly to the new presumptions of no beneficial use, under 1915-25-9, OCD is effectively hardwiring flawed thresholds and procedural determinations into an inactive well framework. The commission should reject the proposed amendments as drafted. If an inactive well list is to be maintained, wells should be added only after case-by-case evaluation of risk and beneficial use, not automatic consequences of failing arbitrary production or injection levels. At a minimum, the rule should allow operators to demonstrate beneficial use before production volumes and should preserve OCD's discretion. So linking compliance to registration and financial assurance approvals, operators who fall even temporarily out of compliance with plugging or flaring requirements could be barred from registering or transferring wells from releasing releasing assurance. Faced with such uncertainty, and this is significant when I say uncertainty, many operators will choose to plug wells rather than risk regulatory deadlocks or compliance or enforcement.
And that also promotes waste, correct?
Absolutely.
All right. So what other proposals create the risk of waste via premature plugging, according to slide 86 of your exhibits?
So at a high level here, the expanded definition of marginal and inactive wells, the shortened compliance window under 1915-25, 90 days to 30 days after 12 months, elimination of risk-based individual well assurance requirements and blanket bonding alternatives, going to this $150,000 per well bond, market realities of the surety industry, and we'll have an expert talk about this, but even having that industry do this, and I'm not, a surety expert, but I've had to get a lot of bonding for a lot of different operators. And then reducing the current 15-month time frame for well inactivity to 13-month inactivity. Those are those general things that I'm concerned with.
Okay. And the final slide of your rebuttal, what are your closing remarks and conclusions for the commission, Mr. Arthur?
And I've been in the regulatory environment since the 1980s. I've developed federal regulations. I've helped states with their regulations in a variety of cases. And, what concerns me when I look at some of this is the longest producing well in America is in Pennsylvania. If that well was in New Mexico, it'd have to get plugged. The first well drilled in Tulsa, Oklahoma was drilled in 1901. It still produces today. It's produced over 1 million barrels of oil, produces about a quarter to half a barrel a day. And they're able to do that because the guy who owns a well, it's on his ranch. He walks out about 100 yards, every day and flips a pump on for about an hour. So there's a variety of different things. We're every operator isn't the same. Every operator isn't a Shell or Exxon or Oxy. There's a variety of these across the board, and I hope we look at that and do that. And I notice I also, have heard multiple times the term bad actors used, and I 100% agree. I do a lot of expert work for the Securities and Exchange Commission on fraud cases and so forth. So I've worked with the SEC to go after bad actors, but it's also the responsibility for the OCD already has regulations to deal with those bad actors and could take those into hand with the regulations that they have. So I would just say, don't unnecessarily punish the small operators. Don't just assume because you have marginal wells or inactive wells that those necessarily are risky. They're all not like that. Those wells that the OCD expert that was plugging looked at. So they're all very different. They were drilled in different times with different rules and so forth. And the potential that we have going forward is significant, just like the example that Oxy had. And we don't have these one size fits all decline curves that you can do for all the wells in New Mexico and apply that across the board. They're all different. You recomplete and the curves change, and so that holdback window can change 50 times over the life of a well.
Sure. Madam Hearing Officer, we do have just a handful of rebuttal slides to go over. I don't know if you want us to proceed or if you want us to.
I think proceeding is good.
Okay. Give us just a second to get that up. All right, Mr. Arthur, you had some comments in response to the testimony from applicants and OCD in this proceeding that you wanted to discuss in rebuttal, correct?
Yes.
Okay.
So this first one kind of related to a comment that Mr. Purvis made, about the West Texas, well, the zombie well. Our firm is actually doing work for the landowner of that zombie well, but the subject well and multiple wells in that area were plugged back in the 1950s. Technology was vastly different. Regulations were very different. I worked at EPA, when we developed the Safe Drinking Water Act amendments of the U.S. UIC program to develop what an underground source of drinking water is. That didn't happen until, the 80s. So you look at the things that were done here. People plugged wells as was the industry standard, as maybe if a state had a plugging regulation that they would do that by. But they certainly didn't anticipate, the fracking boom or injection or all these different things that could happen in the future. So those subject wells were plugged back in the 50s. Regulations were very different. Lumping old historic wells and standards into categories with far newer wells and standards is just wrong and inapplicable. So claims that plugging costs have increased was another thing that Mr. Purvis noted. And I'll say that I'm currently Vice President of Plugging Operations for CSR Services, which is a plugging company. I was part of another one in the Mid-Continent. But what I'm seeing from that is, pluggers are, in some areas costs are going up, in some areas costs are going down, but a lot of it depends on the well. And if you're plugging wells in a forest or next to a house or that is 100 years old or in a corrosive environment. But what I will say is one large Mid-Continent plugging company plugged last year, this would have been 2024, about 1,200 wells, an average cost of about $10,000 per well, a little under that.
All right. And on your next slide, you discuss options that are alternatives to plugging that are available for these types of wells. Can you walk us through that, please?
So this is one example, but certainly there's state and federally funded plugging reclamation programs, industry groups, private sector incentives. But returning production or to recomplete wells for improved production. So for instance, one of the projects that I've been working on for the last several years is short radius horizontal redevelopment of wells. So in this one case, we're taking wells that were initially discovered and drilled from about 1905 to about 1925. Where production had fallen, many of them were temporarily abandoned. We went in with the operator and started doing horizontal recompletions. Productions for the producing wells went from about 1 barrel of oil a day or less to about 20 barrels of oil a day. That's been maintained. And as that operator gains money from that production, they do another well that they do the short radius horizontal redevelopment. And so far they've done about 50 wells. And that's been over the last 4 years. But some of these wells had been shut in, we're talking about 6 or 8 years, decades. So this is significant, and I'll just say that if you look at short radius horizontals and the way these are being done, it's significant. But you look at, and I hate to go on here, but if you look at a lot of reservoirs, when we look at the amount of reserves that we get out of those wells through primary production or even secondary, it's very small. And moreover, what we saw in this particular area with this operator I'm helping, and now we're doing this in a number of places, but an operator will go in and frack a well that maybe is a relatively shallow well and think that the frack, like modern frack, it's going out horizontally. And when in fact, it's not going that far horizontally, it's mostly going up, vertically, and they're missing out on all these other reserves away from the wellbore. And things like these short radius horizontals let them get out to that oil that could be otherwise produced. And if you didn't do this, those reserves would be lost forever. They wouldn't have known it. Did they have to take a chance to see if this would work? Yes. Is that speculative? Not by my term, maybe by one of the other experts, but certainly not by me. And there's a lot of other. This is one example of many things that we're seeing, including chemical additives and so forth, and for unconventional wells that we've seen take production more than double. By just the way they stimulate a well.
All right, and moving on to your next slide, which I think you wanted to address some of Welk's technical experts' testimony, Mr. Alexander. What would you like to note for the commission with respect to his testimony?
So Mr. Alexander essentially dismissed the fracking boom, and I thought that was shocking. While Mr. Alexander was at Southwestern Energy, I was a consultant to Southwestern Energy and worked with them. I didn't work directly with him, but a lot of the people around him. But I was able to argue in Pennsylvania Supreme Court on a case noting that hydraulic fracturing had been around since the early 1900s, and it has. But that early hydraulic fracturing was using, dropping torpedoes with nitroglycerin in them to frack a well, and what you got was very near wellbore fracking. And then around 2010, when horizontal wells were being fracked in areas like the Bakken or the Barnett, they were single stage frack jobs with not the volumes that we use now, not multi-stage frac, none of that, and a lot of the way we do it, the process, the sand, all that is very different. But if you look at before the fracking boom, we were arguing this thing, and this was papers published all over the place about peak oil. And the thought was that in the world, we have reached the point of peak oil. So oil had peaked. It was, we were going to start on the decline, and it was going to run out, and we're going to be out of oil. And as a result of the fracking boom, that resulted in, the shale revolution, which was the biggest, oil boom in our history. So, was that, I mean, to dismiss that, or to say, that, there was no fracking boom and then the fracking was the same? No, I can give you even more examples. One, when we started doing the first well, horizontal well, attempting to frack in the Bakken, we met with Halliburton and one of our clients, and we said we wanted to do a large fracking job on a horizontal well. Halliburton told it was technically infeasible and would cost $1 billion. A year later, we fracked that well with Halliburton, and they modified, pumps and stuff on site, and it worked. So that use of a rigid definition like speculative also in the context is there's no more future potential for older conventional wells in today's age. Technology is advancing at exponential pace with AI data centers and microgrids and the need for gas. I mean, what I've told people, and I've seen uh, in much of the press and people doing things is we need every molecule of energy that we can get. If industry didn't take risks and would be somewhat speculative, there wouldn't be an oil and gas in the world today. There wouldn't. Assumptions presented are highly generalized and lack real world credibility. So I'm just trying to say, like, if we're going to talk about this stuff, let's be honest and dig into the details and not use these generalities.
Right, in your last slide, Mr. Arthur. I think you want to touch on kind of the potential for technology building on what you just said. Can you please quickly go over this slide before
Sure.
we wrap up your rebuttal testimony?
Sure. So unfortunately, the creativity of the energy industry and technology advancements are often overlooked, just like they were for the fracking boom. But as I noted before the fracking boom, the key predictions were the oil production had peaked and, we're going to have to find something else. Then curiosity, creativity, and technology advancements led to one of the biggest oil and gas booms in history. It's common for professionals, especially university types and so forth, to assess economics based on only limited data that primarily relies on selective history and general data without considering how much technology has advanced or actual details. So failing to account for creative alternatives to the norm through things like applying technology advancements can yield findings that are simply misleading and short-sighted.
All right, Mr. Arthur, thank you so much for your testimony today. Madam Hearing Officer, that concludes our direct rebuttal and surrebuttal. At this time, NMOGA would move to admit the direct testimony of Mr. Arthur. It's Appendix A. Mr. Arthur's rebuttal testimony in its Appendix A. The two demonstrative exhibits used for the summary of his direct examination and surrebuttal testimony to the record.
I'll pause for a moment in the event there are objections. They're admitted. Thank you.
Thank you.
We will need a break before public comment, so let's come back at 10:04. Right, let's come back from the break, please. We are on day 7 of the hearing in OCC 24683 regarding well plugging and financial assurance. We've reached another public comment session. We have public commenters in the room and public commenters online. Just a few things about public comments. One is I will ask you to state and spell your first and last name. I will ask you pursuant to the commission rules whether you swear or affirm to tell the truth. And I will ask you to keep your oral comments to 3 minutes. If you have more to say than that, please submit your written public comment to Sheila Apodaca there at the back of the room. Her email address is in the public notice. Let's see, Doug Micklejohn. We saw you come into the room first. If you would join us up here at the witness stand. Hello, would you state and spell your first and last name?
Thank you. First name is Douglas, Douglas. Last name is Micklejohn, M as in Mary, Eiklejohn. That's all one word.
Thank you. Do you swear or affirm to tell the truth?
Yes.
I'll start your time.
Thank you, Madam Hearing Officer. Commissioners, I am a water quality and land restoration advocate for Conservation Voters New Mexico. Conservation Voters urges you to adopt the proposed revisions to your regulations governing the posting of financial assurances for oil and gas wells. First, you have a responsibility to protect the residents of New Mexico and the state's resources by requiring the posting of adequate financial assurances by oil and gas operators. Second, fundamental fairness demands that if an entity makes money drilling for oil and gas in New Mexico, that entity should have to pay any cleanup cost that is required after the drilling is finished. Third, the current regulations do not provide that required protection. In the last approximately 5 years, about $100 million in public money, that is state and federal funds, has been used to clean up abandoned oil and gas wells. Moreover, abandoned wells pose serious threats to New Mexico's groundwater, which is the source of drinking water for about 80% of the residents of New Mexico. For these reasons and the reasons provided by the petitioners and their witnesses, Conservation Voters New Mexico urges you to adopt the proposed revisions to Section 19.15.8 New Mexico Administrative Code. Thank you for your consideration.
Thank you, Mr. Micklejohn. The other person in the room is Signa Laralde. If you would state and spell your first and last name.
Sure. My first name is Signa, Signa. Last name is Laralde, Larralde.
Thank you. Do you swear or affirm to tell the truth?
I do.
I'll start your time.
Good afternoon, oil and gas commissioners. My name is Signa Laralde. I'm a retired archaeologist. I am speaking on my own behalf in strong support of the proposed bonding rule changes. Although New Mexico has already spent over $100 million in state and federal public funds to clean up orphaned and abandoned wells, there are still over 700 wells to be cleaned up. An additional 4,400 wells are expected to be added to the list in the near future. Cleanup costs for existing wells, that's the current state of wells needing mitigation, are estimated at $1.6 billion. And that doesn't count the God only knows how many future wells that will be added to the list if the proposed rule is not adopted. These figures show why changes in the bonding rules are necessary. The public did not leave the landscape in this mess. That was the oil and gas industry. I have spent considerable time in both the Permian Basin oil fields and the oil fields of northwestern New Mexico, and I've seen these sites firsthand. This abandoned industrial waste is not only a health hazard for rural and tribal communities and a blight on the landscape, it's a huge cost that industry should bear as the responsible party. According to a recent statewide poll, nearly 9 in 10 New Mexicans agree, as well as the State Land Office and the Oil and Gas Division. The responsible party, be it a small independent operator or a large corporation, needs to supply adequate bonds up front for plugging every well they intend to drill, no exceptions. After all, these are the parties that reap the profits from oil and gas extraction. I urge you to vote to adopt the stronger rules on oil and gas bonding in their entirety. Thank you for the opportunity to comment on this important rule change.
Thank you, Ms. Laralde. Sheila, can you pull up Julia Whipple? Ms. Whipple,
Yes.
could you state and spell your first and last name, please?
Julia Whipple, Julia Whipple.
Do you swear or affirm to tell the truth?
Yes.
All right, I'll start your time.
Thank you. My name is Julia Whipple, and I grew up in San Diego, California. I spent 12 years in Sierra Vista, Arizona, and I've lived the last 16 years here in Artesia, New Mexico. While living in Artesia, my family has enjoyed the natural wonders here in the southeastern New Mexico area, to include the Pecos River, Sitting Bull Falls, and Carlsbad Caverns. I earned a Bachelor of Arts degree in multiple subjects from the University of Redlands in California, and I've taught all ages from early intervention with CARC to K through 5 classroom teaching, tutoring all ages, college level teaching for 7 years here in Artesia. I ran our local Meals on Wheels program. The nonprofit program is not only blessed with financial support from local oil and gas companies, but many employees spent their lunch breaks helping deliver meals. The Artesia Meals on Wheels program runs entirely on donations, and volunteers deliver all the meals. Currently, I work in real estate. Although no one in my family currently works in the oil and gas industry, we have all enjoyed the many benefits of living in this area and the support local oil companies have given our community. 4 of my 12 children have benefited from scholarships and support of educational and recreational programs through generous donations from local oil and gas companies. I have one daughter who graduated from UNM with 0 debt. The oil and gas money produced here in southern New Mexico supports the entire state. Overregulation of the industry will cause the economy in Artesia to collapse. In the time I've lived here, I've had good friends move to Texas because the companies they work for have moved their headquarters. Our largest building here in town nearly emptied when EOG moved their main operations to Texas. If the oil and gas industry in New Mexico collapses due to overregulation, our small city, along with many other rural economies in southern New Mexico, will be devastated. Many will lose their jobs and income even if they aren't working in the industry. The generous companies in our area sponsor many community events and give our city great support. I ask you to consider me and families like mine when you decide on the future and the regulations of the oil and gas industry. Thank you for your time.
Thank you, Ms. Whipple. Do we have Pauline Hovey? Ms. Hovey, can you unmute yourself?
Yep, I think I did. Okay, thank you. Yes, my name is Pauline Hovey. I'm a citizen
Wait,
resident. and
hold on
taxpayer.
I'm sorry, hold on 1 second. I have to ask you to spell your first and last name.
Oh, sure. Okay, Pauline, Pauline. My last name is Hovey, Hov as in Victor, EY.
And do you swear or affirm to tell the truth?
I do.
I'll start your time.
Okay, thank you. So my name is Pauline Hovey. I'm a citizen, resident, and taxpayer here in New Mexico. I also happen to be a Christian who cares for our land and our neighbors. And I know that for the most part, we New Mexicans are not wealthy people. Many of my fellow New Mexicans live on limited incomes, barely affording to pay their monthly bills. For me, it's unconscionable and unethical that we, the taxpayers, would bear the brunt of cleaning up after oil and gas corporations that profit immensely from drilling in our state. I believe it's absolutely necessary that we require these companies not only clean up after themselves, but also handle any additional costly messes and ensure that their projects will not create any negative consequences, such as pollution and environmental hazards to our state. To me, that's just common sense. I'm not asking for over-regulation, but that they take up their responsibility. In the interest of all New Mexicans, I'm urging you to please modernize and increase the bonding insurance and cleanup rules to require that all oil and gas companies who do business in our state step up and be responsible for their actions that adversely affect our health, our financial situation, our land, and our natural resources. Please do not back down on this. Don't let them walk away from any harm or messes they create. Let's increase the bonding insurance and let's take care of all New Mexico and all of New Mexicans. Thank you.
Thank you, Ms. Hovey. Do we have Ava Curtis?
Yes.
Hello. Would you
here.
spell your
Yes.
first and last name?
So that's going to be AVA and then CURTIS.
Do you swear or affirm to tell the truth?
I do.
I'll start your time.
Thank you. Good afternoon, Chair, Commissioners. My name is Ava Curtis. I'm speaking today on behalf of myself as a resident of Albuquerque and on behalf of the Rio Grande chapter of the Sierra Club as a member, in strong support of the proposed bonding rule changes. Right now, oil and gas corporations can drill dozens or even hundreds of wells in New Mexico while posting bonds that cover only a fraction of the cost. The Legislative Finance Committee found plugging to cost an average of over $160,000 per well, and some costing as much as $700,000 per well. Because of outdated bonding rules, the public is left paying to plug wells to prevent them from releasing toxins into the air and water. In the last 5 years, over $100 million in public funds, state and federal, have been spent to clean up abandoned wells. Simply put, this is not the responsibility of the New Mexico taxpayers. We still face up to $1.6 billion in future cleanup costs. Consider what $1.6 billion could provide for New Mexicans and for our communities. These abandoned wells don't just create financial risks, they're dangerous. The methane and toxins leak into the air and into our groundwater, harming wildlife and public health, especially in rural and tribal communities. Air quality is critical to our health. Air pollution harms us all, not just leading to respiratory problems, but other less commonly associated problems with air pollution, including neurological disease. New Mexicans deserve safe, clean air, and we don't deserve to be left with a massive $1.6 billion cleanup bill when these oil and gas companies make billions of dollars every year. These rule updates are a chance to finally align policy with common sense. Please vote to adopt stronger bonding measures. Let's protect our air, water, and wallets and make sure that no one gets to profit off of New Mexico while leaving the taxpayers to clean up their mess. Thank you.
Thank you, Ms. Curtis. Is there anyone else on the platform who would like to offer public comment? I see Alicia? Can you unmute yourself? Alicia? It might help to press Control-Shift-M to unmute. All right. Is there anyone else on the platform who would like to offer public comment during this session? Our next session is at 9 a.m. tomorrow morning. Alicia, let me encourage you to work on unmuting and to join us either at 9 o'clock. Oh, wait, is that?
I think I did it.
Just now you did. All right.
I don't know how. I think I did Command-Shift-M or something. Anyway, I was
Great.
trying everything I could just because I'm here. I've been listening all day, and I just wanted to throw in my 2 cents. After listening to all the experts, I think that's really all I have to offer is 2 cents. But I just
Hold on. I need
Okay.
you to spell your first and last name for the transcript.
It's Alicia, Alicia, and my last name is Baumhoff, B as in boy, Omhoff.
Do you swear or affirm to tell the truth?
Yes.
All right, thank you. I'll start your time.
I'm listening to this on the heels of listening to days of Water Quality Commission testing Zoom meetings about the governor's recent decision to let the oil and gas companies dump fracked water in New Mexico's waterways. And I've been kind of sick about that ever since. And this comes on the heels of that and contributes to it, especially since, again, really what we're looking at is the health of the residents of the state of New Mexico ultimately. And even though Mr. Wallace says that, you can't tell if a well is going to cost $150,000 or $1,000, he does admit that the oil and gas industry has had the largest boom in history recently with all of its drilling and fracking. Biden said no more fossil fuels, and yet went ahead and made us the largest producer of fossil fuels on the planet. So we are now heating Europe, and Trump wants to heat India, and we're cooking ourselves in the process. And Mr. Wallace, in spite of this, wonderful boom, this economic boom, doesn't make any mention of the environmental costs of this boom in fracking and oil production. It's not hard to see that every year it gets hotter and hotter. And, my 84-year-old aunt's air conditioner just broke. It's $6,500 to replace. Luckily, I live in Taos, New Mexico, where I don't need an air conditioner. And I live off the grid, and sun heats my house. I don't actually use oil, although I do use a little bit of propane for my stove. But we live in a solar state, and there really is no reason for us to continue polluting at this rate when New Mexicans' health is really at stake. And I think we learned during COVID, you have to put health before wealth. And just because the oil industry might, sponsor some events does not outweigh them taxing people for the cleanup that they've already caused that needs to be done. And what about the future deterioration of our climate, our water, and the things that we really rely on to make our lives beautiful? And I'm just disgusted with the oil and gas industry not being held accountable. And, Mr. Wallace was kind of convincing you don't want to charge people too much and discourage business. Well, if they've had this giant boom, I think they can afford to clean up after themselves, or like what he mentioned in Colorado, go somewhere else. Keep ruining Texas. It's already pretty bad. Nobody cares. They all want to leave Texas and come to New Mexico. Why? Because New Mexico is still nice. But if you kind of ruin one state after another, especially one that could be completely solar, it's a sad, sad thing that's happening. So I just wanted to add that 2 cents, and thank you for listening. And I just am hopeful for a future where we really do go solar in New Mexico and we do discourage pollution of our water and our air. And, New Mexico has a long history of being a dumping ground for much worse things like depleted uranium and nuclear waste. Somebody has got to finally say enough is enough and turn this thing around. It's
Thank you.
possible. It's possible.
Thank you, Ms. Baumhoff. Is there anyone else on the platform who's here to offer public comment? The next session is at 9 a.m. If you have dialed in on your phone, you can press *5 to raise your virtual hand. Colin Underation. Let's see here.
Good afternoon.
Hello. Would you spell your first and last name, please?
My first name is Colin, Collin, and my last name is Underation, Undereration.
Thank you. Do you swear or affirm to tell the truth?
I do.
All right, I'll start your time.
All right. I just wanted to express my concern for the proposed rule change. I work for a small oil and gas company in southeast New Mexico. And while I do support responsible producing, I'm afraid that these rules are going to affect the small company a whole lot more than the large companies. And I depend on the oil and gas industry. My family depended on the oil and gas industry my whole life. And I just want to make sure that the rules are in place for everybody to thrive in this environment. I know that pollution and waste is a big issue, but we need to make sure that the rules we're putting in place don't just drive out the small people and send all the money out of state to the large companies. That's about all.
Thank you, Mr. Underation. Is there anyone else on the platform to offer comment at this time? The next session is 9 a.m. No? All right, we will return to the technical case then. And let's see, Mr. Arthur, will you join us at the front of the room here? Ms. Fox or Mr. Tisdale?
Yes, thank you, Madam Hearing Officer. Hello, Mr. Arthur. We met earlier, but I'm Kyle Tisdale. I'm with the Western Environmental Law Center, and I represent the applicants in this case.
Good to meet you.
As you, and thank you for your testimony today. You filed direct and rebuttal testimony in this rulemaking on behalf of NMOGA, correct?
Correct.
Do you have the direct and rebuttal testimony available and with you?
Yes.
Great. And you're the author of that testimony, correct?
Correct.
Did anyone else help you prepare the testimony?
Yes, I had other people with my firm that assisted.
Okay. Have you reviewed and are you familiar with applicant's proposal and the subject of this rulemaking?
I think so, yes.
Okay. And have you reviewed the pre-filed direct and rebuttal testimony that's been filed by other technical and fact witnesses in this case?
Not every single one, but I've read a bunch of those.
Okay. And I think I heard you say earlier that you did listen to some of the testimony in the last week or so, but maybe not all of it. Is that correct?
Correct.
Okay. Let's begin with the expertise that you're offering in this rulemaking. You're the founder and president and chief engineer of All Consulting, and you've been doing that for over 26 years. Is that correct?
Yeah, 27 years.
Great. And you're a registered professional engineer in 36 states, including New Mexico.
Correct.
But you don't live in New Mexico, is that right?
I do not.
Okay. And through your engineering and consulting practice, you describe being an expert witness on more than 2,500 dockets and more than 100 litigation cases. Is that right?
Yes.
Quite prolific. You must be very busy. By my lawyer math, that's over 100 cases a year for your time as a consultant. Does that sound about right?
It depends. The dockets I referred to are like hearing dockets at various different states. So some of those can occur many dockets in a single day, for instance.
How many cases or dockets are you participating in right now?
Six or seven cases.
Okay. You're not an attorney, is that correct?
Correct.
So while you're not offering your expert legal opinion, based on your testimony, you are familiar with New Mexico's Oil and Gas Act and relevant provisions of the administrative code as it pertains to oil and gas operations in the state. Is that correct?
Generally, I'm not the super expert in every single detail, but yes, I'm the nerdy technical guy.
Okay. And you did go through those provisions pretty extensively in your direct and rebuttal testimony as well as in your summaries so far.
I sure tried to.
Okay. Throughout your direct and rebuttal testimony, you reference the data, statistics, and analysis from various sources, including Energy Information Administration, the New Mexico Legislative Finance Committee, as well as evidence provided by applicants in their direct, among other evidence. Is that correct?
Yes.
Going through your testimony, I didn't see any independent data or statistical analysis that was included. Is that correct?
Yes.
Did you include any independently prepared tables or graphics or calculations in your testimony?
I did not.
I also didn't see a list of materials that you relied upon when forming your opinion in this case. Is that correct?
I believe that's correct.
Okay.
Can I take a look here? Because
certainly.
Just for my benefit, could you repeat the question? I just missed it.
Yeah, I asked whether he listed any materials that he relied upon in forming his opinion in the case.
Thank you.
Yeah, it does not appear that we included that.
Okay. So your commentary in this case is based on applying your general expertise in the field to the work of others in this case. Is that correct?
I'd say in general, yes.
Okay, great. Part 25 NMAC involves the plugging and abandonment of wells with the general idea that after a certain amount of time, an inactive well either needs to be plugged or it needs to go into temporary abandonment status. Is that about right?
Yes.
And under current rules, there's no limitation on the amount of time that a well can sit in temporary abandonment or TA status. Is that right?
Essentially.
Indeed, there are many wells that have not produced any oil and gas for decades, but they're still on that temporary abandonment list. Is that correct?
I would say yes, that's generally the case throughout the country.
Okay. And currently the terms beneficial use or beneficial purposes appear throughout the rules, but they currently don't have a definition in New Mexico. Is that right?
Correct.
And OCD has proposed to define these terms at what would be 1915-27B7 NMAC. And that proposed definition has been adopted by applicants. Is that right?
I don't have all the numbers memorized, but I believe I know what that is. And
it's just the definition, proposed definition of beneficial use and beneficial purposes.
I just would like to, could we pull that definition up so I can see?
I'm not going to probe into that. It's just the general proposition that a definition doesn't currently exist, but it's being proposed in this process, right?
Yes.
Great. For purposes of Part 25, OCD has proposed and applicants have adopted a presumption of no beneficial use. Is that correct?
Yes.
And that presumption includes a rebuttable presumption that a well is not capable of beneficial use if in a consecutive 12-month period the well has not produced for at least 90 days and has not produced at least 90 BOE. Is that right?
I believe so, yes.
Yeah. And did you, I know you said earlier that you didn't hear all the testimony, but did you hear the testimony of OCD Deputy Director Brandon Powell in his suggestion to drop the days of production threshold from this presumption?
I did not hear that testimony.
Okay. And so I assume you also didn't hear, you haven't talked to council about Mr. Powell's description that the days of production criteria could be easily manipulated and that production threshold alone was sufficient.
We did not discuss.
Okay. Now I'm going to go through a few provisions of your direct and rebuttal. I will quote back to you where appropriate. I'm going to try to avoid putting it up on the screen just to save us all the time. If you want me to pull it up, I'd be glad to, but I'm not trying to parse your specific words. I'm just using those as general references, okay?
I tend to prefer seeing it.
Okay.
If that's okay.
Sure. If you need them after I'm describing them, just let me know if that doesn't sound right or if you want to actually look at the language, okay?
Okay.
All right. So at page 8 of your direct testimony, you state, and I think you stated earlier today as well, that the 90-day criteria are too rigid and that operators may intentionally shut in wells for extended periods, often exceeding 12 months. And then you list a number of reasons why that might be the case. Does that sound right?
Yes.
Do you still stand by that statement for purposes of the 90-day production criteria?
I do.
And your testimony, I think I heard you say earlier today, is that that 90-day period should be extended to 5 years. Was that right?
That would be reasonable.
Okay. Even in light of Mr. Powell's description that such criteria at that level could be easily manipulated by industry and that the production threshold alone is sufficient?
I didn't hear his testimony, so I can't comment on that.
Okay. But can you comment on the sort of your recommendation of 5 years versus that recommendation that the days of production be dropped from the beneficial use definition?
I think I already talked about that in my direct testimony that we just talked about, but 90 days is a very short window. I can concur that that there may be experiences where you have wells that that you don't want to maybe extend to that degree, but that's just, I'd say, an unreasonable window.
Okay. So focusing just on the 90 BOE production threshold, that's just 0.25 BOE per day. Is that correct?
I didn't do the math, but that sounds about right.
Okay. And in your direct testimony, you talk about sort of stripper wells as being a category of well that's sort of recognized both in New Mexico and nationally as a low producing well, correct?
I'd say that's reasonable to categorize it that way.
And a stripper well produces 10 BOE per day or less over a 12-month period. Does that sound like the right definition?
There are multiple definitions across the country, but that's generally one, yes.
And the IOGCC talks about that definition, is that right?
They do. They had a report that came out on that. But again, it can vary.
So for comparison, a strip of well is defined as anything less than essentially 3,650 BOE over a year, and the rebuttable presumption for no beneficial use being proposed is just a fraction of that at 90 BOE per year. Is that correct?
It's a portion of it, but I will also say that I know viable wells is the example that I gave that have been producing even a quarter barrel a year for 100 years.
Okay. And for even a well that's producing less than this very small amount under applicant's proposal, an operator still has the ability to rebut the presumption of no beneficial use and thus avoid the plugging of that well. Is that correct?
Technically, that's available.
And you've identified even the type of criteria that could be provided to rebut that presumption, and that could be provided to OCD, correct?
It is, and that on a multi-well basis could be a significant overhead cost to any operator. And is, you know, so with considering that just because it's low producing, it's, you know, it's non-economic or whatever, that's, you know, that's what's partially driving some of this, as opposed to, you know, as opposed to not necessarily coming to a specific assumption.
Okay. Each drilling permit comes with the expressed obligation that the operator plug and abandon that well at the end of its life. Is that correct?
I believe so, yes.
And unfortunately, that doesn't always happen. Do you agree?
Over what timeframes are we talking about? So as we're talking about current drilling permits, are we talking drilling permits that were issued in 1928 when the first well was drilled in the New Mexico Permian Basin?
I'm talking about the general idea that orphan wells exist.
So right now, so the permits, right? Yeah, there's orphan wells exist, but just like some of the comments that we had about this, the costs of, you know, that of plugging that have gone on right now. This is a lot of those wells are old wells that were abandoned by operators a long time ago. Just like the examples that the OCD gave, the number of wells that, you know, get a, you know, that it's not just across the board. So there's good operators, there is bad actors and all that, but so yes, that does happen. I'm dealing with another litigation case right now where there was a bad actor that did exactly that, but by and large, again, remembering that 95% of the wells are plugged by private industry.
But you agree that the OCD maintains an orphan well list. So there's a list of wells that have been abandoned by their operators, correct?
There have been, yes.
Okay. When an operator declares bankruptcy or otherwise walks away from their plugging obligation, those wells are referred to as stripper wells, yes? Or excuse me, correct that. Those wells are referred to as orphan wells, correct?
I would generally say that, but I would offer something within the context of that is that there are bankruptcies. There are companies that go out of business that lose their well. I will also say that that in that line, that isn't, you know, that doesn't mean that everyone that's declared bankruptcy is a bad actor. Nobody expected the price of oil to shoot down to minus $47 a barrel during COVID. I went to work for EPA in the 1980s when oil went down to $6 a barrel because I needed a job, but there was a lot of bankruptcies and a lot of those bankruptcies were big companies.
Yeah.
So it does happen. And the state has a fund that helps with that. Those companies would have been required to have the blanket bonds and so forth with that too. So that it's not like there wasn't financial assurance available and present.
You testified earlier today, I think in your summary that, and you said quote, orphan wells are a problem. Do you recall that?
Yes.
And you believe that's true nationally and here in New Mexico, is that correct?
You can find a lot of stuff on the internet where I've looked at problem wells and so forth, and orphan wells can be a problem. Orphan wells, I'll tell you, they can be an opportunity too. So they can be a problem. It really depends on assessing those wells and looking at the risks. So to be able to say, is every orphan well a problem? I would say no. So orphan wells can be a problem, but in California and other states, they're converting some of those wells, in Oklahoma and Missouri, converting some of them for geothermal energy for long-term battery storage. Louisiana just permitted the first bio-oil injection Class 5, converted an orphan well to a Class 5 commercial experimental well for bio-oil injection, which was CO2 sequestration. So there are opportunities, but they can be a problem. Some of them are purging. Some of them, have been there for decades and decades and decades and have corroded casing, like some of the examples that you saw. Yes.
And I'm reluctant to sort of conflate different sections of the proposed rules, but for both the presumption of no beneficial use as well as the sort of marginal well definition, or the demonstration of putting a well into temporary abandonment status, that is all the type of information that an operator could provide to OCD, correct? That would either justify that a well has a beneficial use, or that justify that a well should be eligible to be in approved temporary abandonment status. Do you agree?
So your question was that an operator could provide, and so what is needed to provide? So, if you're a regulatory agency, and I'm a former regulator and have worked as an expert with multiple state oil and gas regulatory agencies and so forth. But, if I ask an operator, well, you could provide some stuff, as opposed to helping them understand what we need as a regulator, is kind of two different things. So, and moreover, if you're thinking that you're going to, recomplete wells or do an EOR project or whatever, I mean, sometimes, like the Oxy example, that can take a long time. But so you could provide those things that you're thinking of, but you may say, well, we're looking at three different things, three different opportunities to be able to see if what these, what looks appropriate, what looks like will be the best option for us for these wells. And it may turn out that all three of those things didn't work and they find something else.
But the proposed rules allow an operator to take that information to OCD, correct?
They don't prevent it.
Indeed, the proposed rules encourage an operator to take that information to OCD, correct?
They talk about a lot of information that can be provided and so forth, which can be a challenge, but they do allow that.
So you did testify that you closely read the LFC report. Did I hear that earlier today?
Yes.
And in that summary of the LFC report, it identifies that OCD has plugging authority for roughly 700 wells, will likely need to plug an additional 1,400 inactive wells, and that there are more than 3,000 wells at risk of being orphaned. Does that sound correct?
Sounds correct.
And you don't dispute those numbers?
No, I don't have the LFC report in front of me, but that sounds from reading it memory, that sounds.
So according to the LFC, and as you agree, the orphan well problem in the state is poised to become worse. Is that correct?
I would say that there may become more orphan wells. And unless there are, other options for that, but there could become an increase in orphan wells based on what was included in the LFC report. But I have not looked at all of those wells and seen what the viability is and so forth. And I don't know that they necessarily did either.
Okay. The LFC also estimates the state's current and near future liability for well plugging and site remediation at between 700 million and 1.6 billion. Does that sound correct?
That's what they estimated.
And you don't dispute those estimates?
I understand that's what's there. I think that I don't think that they've considered everything that they should have when they put those numbers together.
Okay. Do you know the current balance of the state's reclamation fund?
I haven't specifically looked at that, but I want to say it was like $46 million or something like that.
66 million, but does that sound right?
Sounds about right.
Okay. And are you aware that New Mexico has received 55 million roughly in federal grants through the Orphan Well program and is eligible for 111 million more in federal grants?
I am.
So even with the federal grants, there's a massive gap between the amount available in the reclamation fund and the state's near-term plugging liability. Would you agree that's correct?
Based on what the LSC assumed, based on relatively high plugging rates, that doesn't account for instance, some of the testimony that I provided that wells can be plugged for a lot less often.
Okay. But you agree that this gap represents a major financial risk to the state?
I don't know that I necessarily do agree with that, because I think that, a lot of what the states have been getting money for, and that you've seen on plugging have been high risk wells, wells that did have exactly like the examples that the OCD witness showed, was wells that were in significant disrepair and problems. And they're all not like that.
And you testified earlier today that OCD takes on the worst of the worst.
They often do, but I would also say that it, based on my experience with the state plugging stuff, they cannot do things like sell pipe, where an operator can, so they're not allowed to. So there's different things, from both well plugging and site restoration. So we just cleaned up another site that I was involved with that at a zero net cost by essentially selling all the surface equipment, tanks and pump jacks and all that kind of stuff, to offset the actual restoration cost. So there's, is there truly this massive, disparity about the potential of what is going to be needed versus what is actually there? I don't know that work has truly been done.
Okay. When a well becomes orphaned, it is the state that plugs that well. You would agree?
Are we talking in all cases? So on federal land or on tribal land, or just but I would say generally it is, but there's also
exceptions to the rule.
There's also many exceptions to the rule. So for instance, in the state of Texas, a landowner can get partial plugging from the state, like half of the estimated plugging costs, and they would take on the other half and plug the well. There's, companies that are plugging wells for carbon credits. There are
how about,
all sorts of different things.
Here in New Mexico,
that
orphan wells are plugged by OCD. Would you agree with that?
Unless they're plugged by someone else, but that's their OCD is the primary.
Okay. And financial assurance operates more or less like an insurance policy for the state in the event that a well becomes orphaned. Would you agree with that?
I'd say that's correct.
And financial assurance is required by the Oil and Gas Act, correct?
It is.
So it's then the cost to the state and not the operator that is relevant for the plugging of orphaned wells. You would agree with that?
Well, less the amount of financial assurance that that operator had in place.
Sure. And according again to the LFC report, the average cost to OCD to plug a well is $163,000. You'd agree with the LFC report that that's what the LFC report stated?
That's what the LFC report stated and base their numbers off of, which is, that's like saying I'm going to build the Empire State Building, I'm going to build a small 2-room, shack, and they're both going to cost the same.
Okay, but that is the average cost for OCD for their plugging, right?
For the plugging that they've done so far on problem wells, yes.
Okay.
Which is different than plugging costs for wells across the board.
And so current blanket plugging financial assurance for active wells right now, currently, is set at a maximum of $250,000 for operators of more than 100 wells, correct?
Correct.
So based on OCD's average cost to plug, that would amount to less than 2 wells plugged, correct?
Based on that plugging cost for problem wells, that's correct. However, as I noted, many wells don't cost anywhere near that amount of money to plug. So, whether it's OCD or an operator, all the wells don't cost that much.
Okay. You would agree that a well that's producing a lot of oil or gas doesn't have much near-term risk of becoming orphaned, right?
I've seen wells that had higher production rates become orphaned. So for instance, if you look at the number of companies that went bankrupt during the COVID pandemic and oil hit minus $47 a barrel.
Sure.
There were some companies that went bankrupt that had high producing wells. In 1982, I was working for a company and Penn Square Bank went bankrupt, and every company that had loans through them got forced into bankruptcy. So yeah, can you have higher rate wells that become orphaned? Yes.
Those would be exceptional circumstances that a high producing well, an operator would walk away from. Would you agree with that?
Similar exception to the extraordinary plugging costs that the LFC report, showed from based on OCD's averages that don't align with normal operations. So they're both looking at extremes.
Okay. But then, just sort of thinking about that, your testimony is that a well that's producing less than 90 BOE over the year, that those wells have a lot of utility, right? But that a well that's like highly producing oil and gas, an operator would still walk away from that. But there's a little contradiction there. Would you agree?
Are you suggesting a well that produces 90 barrels of oil that, an operator wouldn't have a problem walking away from?
I'm suggesting that there is a presumption of no beneficial use for a well that produces less than 90 BOE. There's that presumption is rebuttable, but
I know a lot of small operators, family operators, that wells like that are critical to their future and their livelihood.
Okay. In both your direct and rebuttal testimony, you advocate for a risk-based bonding approach. Is that correct?
Yes.
There's many ways to quantify risk. You would agree with that?
I do.
And in your direct testimony, you offer that risk-based bonding should consider operator compliance history, well condition, asset maturity, and demonstrated plugging costs, correct?
Those are some of the things to consider. I mean, I helped the OCD develop the risk-based data management system. So the idea of risk can include a number of different things. So you have to look at that with an experienced eye and decide what is most appropriate, I'd say.
Neither you nor any party that you're aware of have provided any specific framework that would increase existing financial assurance to account for these enumerated risks?
So I have not, I'm not aware of that. I will say that the Groundwater Protection Council is modifying the risk-based data management system for idle and orphan wells to account for some of these kind of risks, and including the things in there, and have been working with different state oil and gas and other agencies in that, but they're just starting that process now.
At page 87 of your rebuttal, you and in in your rebuttal, responding to applicants' financial assurance recommendations, you register concern with any increases in paperwork or administrative processes, stating that OCD is already inundated with documentation. Is that right? Does that sound right?
What lines on page 87?
It starts at line 2001 and goes to 2002 on page 87.
Yes. Yes.
And then on page 13 of your rebuttal, you state that the commission should reject arbitrary volumetric cutoffs in favor of a case-by-case assessment that accounts for market conditions, reservoir characteristics, and long-term field development strategies. Does that sound right? That would be.
Could you ask that again?
Yeah, on page 13 of your rebuttal, you state that the commission should reject arbitrary volumetric cutoffs in favor of a case-by-case assessment that accounts for market conditions, reservoir characteristics, and long-term field development strategies.
Yes.
How do you square your recommendation to assess the risk by considering operator compliance history, well condition, asset maturity, and demonstrated plugging costs, as well as making a case-by-case assessment that accounts for market conditions, reservoir characteristics, and long-term field development strategies, while also avoiding paperwork and administrative processes to OCD?
So that's an interesting question, and I think kind of goes to part of what I was talking about, because OCD already has a lot going on, industry has a lot going on, and I think what we're seeing on an overall perspective is that having data management systems, AI, whatever, that can help us with those things. Because what I did, I got to serve as a consulting expert to the DOE, DOI, and EPA for the MERP program, looking at well plugging of potentially, uneconomic marginal wells and idle wells. And what we did and what I helped them with is they came up with, and I worked with them as well as the U.S. Geological Survey on a program to actually assess risk based on a lot of those things that you're talking about, that also include wells that have had like mechanical failures in the area and so forth. So we have a lot of data that we don't necessarily always use, and it can include things like well depth and production in the area and mechanical integrity failures and non-compliance and all those different things. And I will say that DOE has come up with an app that goes in that direction, but I would say it's like version 1.0. So there is work in doing exactly what you're talking about. But it's, you know, if you really look at this effort of where orphan wells, let's say, or even the inactive, idle, marginal wells have gotten so much attention, all of this has really happened, I would say, just in the last short few years. And there also winds up being a lot of mischaracterization, like we saw with some of the public comment in reviewing some of the liabilities when a lot of those wells being plugged are old wells, you know, that with, you know, operators long gone and things were very different, and there were different rules and regulations and so forth. So I think we've got work to do. I think that just based on my discussion with NUMOGA, they would be very open to working with, you know, OCC and OCD on trying to develop and refine things that made sense there. My guess is that between the federal government, state of New Mexico, DOE, IOGCC, GWPC, you know, and so forth, and even EDF and WELC and whatever, that there could be a lot of really good stuff happen. And I would sure rather see us like launch some great things so that we can control contamination and emissions and all those things in a more healthy manner that isn't just, oh yeah, we're going to run a bunch of companies out of business because they're small. Like I'm a big believer in small businesses and so forth.
Yeah. Neither you nor NUMOGA has offered any specific recommendation for how a case-by-case financial assurance framework would work. Is that correct?
I wasn't asked to do that. I don't know if NUMOGA has done that.
You haven't done that, though, right?
I have not done that.
Okay. Throughout your testimony, you raised concern that the definition of marginal well and the presumption of no beneficial use will result in premature plugging of wells. Is that correct?
Yes.
For example, page 4 of your direct, you state that this approach would disproportionately impact smaller operators and those with large portfolios of marginal or inactive wells, potentially accelerating the premature abandonment of wells that remain economically viable. Does that sound correct?
I'm trying to find that.
I'm not going to hold you to the exact language, but
there you come on.
That's at
yes.
line 75. Yeah.
Yes.
And at page 13 of your direct, you state that the 90-day criteria in WELC's proposed presumption will likely lead to the premature plugging of viable wells, contrary to the commission and division's mandate to prevent waste and protect correlative rights. Is that correct?
Yes.
And that's something sort of consistently that you raised in your testimony, is this idea of premature plugging.
I very much understand the need to hold industry accountable, to maintain compliance, for OCD to address bad actors when they have them. They have rules now that they could be enforcing that I don't necessarily always see. But within this, yes, that's an issue, but we have I would say, a similar responsibility to make sure that we don't do things that create waste. These resources are critical. They're critical to New Mexico's future and now, so we want them developed responsibly.
Yeah, great.
Mr. Tisdale, you have 5 minutes.
Thank you, Madam Hearing Officer. At page 113 going into 114 of your rebuttal, you state that proposed changes risk forcing premature plugging of wells that serve important roles in lease management, reservoir balancing, and future recovery. Is that correct?
Reservoir management or canopy for recompletion or refractures.
Yeah.
So yes.
And these other purposes of a well, lease management, reservoir balancing, and future recovery are consistently raised throughout your testimony as reasons for not plugging a well that is no longer producing. Is that correct?
Yes, and those are examples, so not an exhaustive list.
Sure. I want to talk quickly about lease management. So I understand this is where a well that is either not producing or producing a very small amount, and for purposes of the presumption of no beneficial use, that would be less than 0.25 BOE per day, could nevertheless hold that lease or unit, if there was a unit, to keep that lease from expiring. Does that sound right?
That's correct, but even a well producing 0.25 barrels a day on an overall, lease production could be significant. And I've seen cases where you had wells that were holding a lease, producing a small amount of production, so that the operator could get investors and funding to be able to do a bigger project like an EOR project.
But even inactive wells, you've stated in your testimony, could still serve a purpose to hold that lease or unit.
Yes, as operators look to alternate zones or potential recompletions or whatever, yes.
So that whole lease or even an entire unit wouldn't be producing oil or gas, but according to your testimony, such a well still has a beneficial use. Is that correct?
Yes.
Can you explain how tying up that lease or unit in non-production for perhaps years would serve OCD's mandate to prevent waste?
So once those wells are plugged, let's say, oftentimes those resources are lost forever. So imagine if you have those resources underground and you have this well that has access that allows you to do logging, geophysical logging, or perforating, or testing, or whatever that is, as you're evaluating perhaps a lease, an area, a region, a basin, or various different things. Sometimes that can take a long time to do.
Sure.
And having that access there can be critical. I've seen it. And once you give up on that well and you plug it, it's over. So yes, somebody could come in and say, drill a new well, but now they're having to deal with more speculation than they may have had they had access to that well, so that they could do, like I said, geophysical logging or sidewall coring or whatever.
Okay. Thank you, Mr. Arthur. I appreciate your testimony. No further questions.
Thank you, Mr. Tisdale. All right. We'll break for the night, resume at 9 in the morning with public comment and continuing examination of Mr. Arthur. Good night.
It was on the newsletter. So the available list. I don't know that it matters either way. If you want to file it publicly, that's fine. If you want to disregard, that's fine. Okay. No, that's okay. Thanks.